All right, good afternoon, everyone. I'd like to now declare open this public hearing of the Parliamentary Joint Committee on Intelligence and Security for its review of the Anti-Money Laundering and Counter-Terrorism Financing Amendment Bill 2026. I begin by acknowledging the traditional custodians of the land on which we're meeting today and pay my respects to their elders past, present and emerging. Now, these are public proceedings, although the committee may agree to request to have evidence heard in camera, or may determine that certain evidence should be heard in camera. I do remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege, unless you are given evidence from outside of Australia. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Parliament as contempt. It is also a contempt to give false or misleading evidence to a committee. Now, both houses of the Parliament have resolved that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked to a superior officer or to a minister. And this prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. As the Chair, I'll ensure the proceedings are conducted in an orderly, respectful and courteous way, and I remind all committee members of their obligations under the Behaviour Code for Australian parliamentarians. Now, in accordance with the committee's resolutions of 26 August last year, this hearing will be broadcast on the Parliament's website, and the proof and official transcript of proceedings will be published on the Parliament's website. The hearing today is being conducted with most members, in fact I think all members, remotely by video conference. Members and witnesses participating remotely are reminded to mute your microphones when you are not speaking. I'd like to now welcome representatives from the Australian Banking Association, Mr. Chris Taylor, to give evidence at this hearing today. Now, for the Hansard record though, could I ask that you state your full name and the capacity in which you appeared before today's committee, please?
Thank you, Chair. My name is Chris Taylor and I'm Chief of Policy at the Australian Banking Association.
Thanks, Mr. Taylor. Now, although the committee does not require you to give evidence under oath, I should remind you and advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of their respective houses. The giving of false or misleading evidence is a serious matter, and the evidence today will be recorded by Hansard and attracts parliamentary privilege. Now, I just want to ask, did you have an opening statement before we kick off with questions?
I do, Chair.
Please proceed.
Thank you, Chair and members of the committee, for the opportunity to appear today on behalf of the Australian Banking Association. Banks are at the front line of Australia's effort to combat money laundering and terrorism financing, and the industry is committed to a regime that protects Australians and the integrity of it. This bill goes to the heart of that effort, keeping the regime effective and fit for purpose as financial crime evolves, and the ABA supports its policy intent. I'd like to set out our position on each of the three schedules and the matters we ask the committee to consider further. Let me start with Schedule 1, the new AUSTRAC CEO power. First and foremost, the ABA supports a new power for the AUSTRAC CEO to restrict or prohibit high-risk products, services or delivery channels subject to appropriate safeguards. The financial crime environment is evolving constantly, and it is critical that the regime is set up for success to be able to keep pace with this reality. A power of this reach has to be properly scoped, independently reviewable, and exercised in a way that preserves room for innovation and does not disrupt well-regulated sectors. This bill picks up several of the important safeguards we recommended through earlier consultations, including minimum public consultation periods, mandatory other regulator engagement, and having decisions subject to parliamentary oversight through disallowance. Our submission, however, sets out a few additional safeguards we consider appropriate, particularly the request for a decision to be subject to merits-based review, which would align with similar powers from other regulators such as ASIC. Once the power is in place, the clearest case for using it is crypto ATMs. The Australian Banking Association has long advocated for action against crypto ATMs, which have been linked to significant scam-related activity, high-risk cash-based transactions, and the rapid movement of illicit funds. AUSTRAC's own data underscores the scale of this problem, Crypto ATMs in Australia handle around 150,000 transactions and move close to $275 million every year. After interviewing 90 of the 100 most prolific users of crypto ATMs at the start of 2025, AUSTRAC estimated that about 85% were scam victims or money mules coerced into moving suspected illicit funds. AUSTRAC also identified the 60 to 70-year-old age group as among the largest users of crypto ATMs, a demographic that is not only particularly vulnerable to scam-related coercion, but is also not a demographic that traditionally uses or purchases cryptocurrencies. These are not abstract numbers. They represent Australians losing real money to scams through a channel that moves funds fast and out of reach. Protecting Australians from this type of harm is exactly what this type of targeted power should be used for. On that evidence, and with no demonstrated legitimate use case, the ABA strongly supports applying restrictions or a prohibition on crypto ATMs as the appropriate first use of this power. On Schedule 2, the definition of financing of terrorism, we're pretty brief. We support these changes. They update the definition to capture the new offence of financing a state sponsor of terrorism and keep pace with developments in Australia's sanctions laws. On Schedule 3, Schedule 3 makes a series of technical amendments. I'll cover a few of the headline points. We welcome these changes made to the bill. We recommend several further amendments as we set out in our January feedback to the department, and I'll give you two examples now of additional context. The first concerns persons acting on behalf of a customer. The bill rightly removes the obligation to check whether that person is a politically exposed person, but keeps it for targeted financial sanctions. This residual obligation should also be removed. The two checks are often done together, and this is not supported by actual risk. The second is the definition of senior manager. We support having a suitably senior person responsible for the approvals required under the Act, but the definition needs to be appropriately flexible, particularly for large and complex institutions. We'd welcome a chance to have an alternative form of this drafting in to make sure that this is workable for organisations of all sizes. These are small, targeted changes, but they do keep the effort directed at genuine risk rather than compliance for compliance's sake. The ABA supports the objectives of this bill, and the industry is committed to an effective, risk-based regime that protects the community and the financial system. Thank you, Chair. We'll be pleased to take your questions.
Thanks a lot. Now, I'll hand the call over to Senator Cash, and then I'll see if Mr Laxwell has any questions.
Thank you very much, Chair, and thank you, Mr Taylor, for your opening statement. What are the key metrics that the banks will use to assess whether the changes in the bill are actually achieving their intended effects?
I think that will depend on which of the schedules that you're talking about. In terms of Schedule 1, the new AUSTRAC powers, we think that this is an important new power for the AUSTRAC CEO to ensure that their restrictions are able to keep pace with the change and new risks that emerge. As we've said in our submission, we think that the first use of this should be in appropriate conditions or restrictions for the use of crypto ATMs. We have, in our previous engagement with the department, suggested appropriate safeguards. This is a very broad power, and as such, it needs appropriate safeguards in place. We are very pleased to see that the bill presented before yourselves includes mandatory consultation with other departments, and also is subject to disallowance. But as I said in my opening statement, we think it's important that the bill includes a merits-based review, which would align with similar powers currently held by other regulators, including ASIC. I don't think we have anything further to add in terms of success metrics on Schedule 2. We view this as an alignment amendment. But on Schedule 3, the objective of these technical amendments is to ensure that the requirements in the bill are proportionate and sensible to the risk. We think these are good measures. We always think that there could be improvements on them, and we have set those out in our submission, but that should be a key objective of your review of this bill, is to make sure that the changes are proportionate and sensible for the risk that you're considering.
From the banking sector's perspective, would regular or semi-regular reporting help industry understand how AUSTRAC is using the new high-risk mechanism powers And I suppose would such reporting be likely to help banks adjust controls and risk settings more effectively?
I think banks and AUSTRAC have the same shared objective, which is an effective anti-money laundering and terrorism financing regime. If that additional transparency would help in that objective, I think that is something that my banks would support.
Okay. After the commencement of the legislation, would some kind of formal review, so perhaps at the 12-month mark or sometimes slightly beyond that, would that be likely to help assess whether the new powers are actually reducing the harm to bank customers? Is that something that the committee should be putting forward?
Senator, we haven't raised that as an item in our submission. Again, though, these are fast evolving areas. New technologies are being used, new techniques are being used by money launderers, by criminal syndicates. So again, I think this is an area that will need to continue to be the focus of ongoing review and engagement with AUSTRAC. So while we haven't asked for that, we certainly wouldn't stand against continued evolution of Australia's anti-money laundering regime.
Thank you. As things currently stand, can banks fully and comprehensively identify spending patterns overseas that may indicate terrorist financing risk or terrorism financing risk, or are there potential changes or reforms that could be implemented to improve that capacity?
Senator, I might have to take that question on notice. It's a technical one. I'm happy to consult with my banks and come back to you with a more granular answer.
That would be greatly appreciated, Mr. Taylor. In answering that question, could you also then perhaps look at, would banks support a requirement to apply enhanced due diligence where a customer's transactions coincide with travel to a high-risk designated region?
Certainly, Senator, I'll be happy to take that question on notice.
Brilliant. Thank you. Do you acknowledge the concern of lawful, compliant operators about the bill, that there are restrictions being placed on an entire delivery channel rather than simply on the non-compliant operators? And are there changes that you think should at least be considered in that respect?
As I said in my opening statement, Senator, I think it's important that where you're giving broad powers, such as the powers included in Schedule 1, that they are done with appropriate safeguards. We feel those safeguards, which we had suggested in our consultations with the department, are very helpful at ensuring the exercise of these powers is appropriate and proportionate to the risk. The only additional suggestion that we have made in our submission to your committee has been the ability for a merits review in addition to a review by yourselves through a review of the legislative instrument and a disallowance power.
Yeah. So can I just go on to that? So my final question had actually been in relation to, do you think a greater emphasis should be placed on independence merits view? And you've clearly articulated that both in your opening statement and in your previous answers. So the answer is yes, a decision should be subject to a merits-based review. You have referred in your opening statement and again just in the answer given to my question to the feedback that you'd provided to the department during the initial consultation. Chair, can I just confirm that we have a copy of that feedback as well, just so we can ensure that the feedback has been taken on board? You've said that you are satisfied now in relation to the safeguards, that they are reflected in the bill, but for the merits-based review. Is that correct, Mr. Taylor?
Yeah, it is, and I believe we've actually attached the responses back for that review to our submission to your committee as well. But if I haven't, I'd be happy to do that on notice.
Okay. No, so we'll go through them. So, no, thank you, Chair. That, at this point in time, are my questions, and I look forward, Mr. Taylor, to receiving the answers to the two that have been taken on notice.
Thanks, Senator Cash. Now I'll see if Mr. Luxall have got any questions for this witness.
Thanks, Chair. Thanks, Mr. Taylor, for your addressing this inquiry. I've got a couple of questions, if that's okay. Both AUSTRAC and in the explanatory memorandum and in your opening statement, you've identified these crypto ATMs as high risk. I think that's pretty clear. Just from the banks, from your members' perspective, what are the key risks associated with these ATMs over sort of other services?
Certainly. I think there's a few of them, and they each relate to sort of different harms. What the AUSTRAC data has shown is the main people using these ATMs are people who are either being scammed or acting as money mules. Purchasing cryptocurrency is something people should be free to do. When they purchase cryptocurrency by literally feeding physical cash into a crypto ATM, they can pay fees somewhere in the order of 17 to 19%, sometimes even higher. When you're measuring a commission in percentages rather than in basis points, which you might get if you were buying cryptocurrency in an online capacity, there's clearly some degree of consumer harm or some risk of consumer harm going on. And AUSTRAC's data is clearly showing that people who are using these ATMs are either themselves subject to a scam or they are involved in money mule activities, which is helping moving criminal proceeds either from scams or from other types of illicit activities. So where we really struggle to see a legitimate use case here, certainly the data from AUSTRAC seems to be suggesting that they're mainly being used for activities that involve a very high degree of consumer and broader harm in our community. And as such, this is exactly the type of issue that this new broad power should be looking at further.
Are there any other examples of sort of similar mechanisms that would sort of meet that threshold of high risk that you could, because we've been given one example, but do you know of any others that deserve the same treatment?
We haven't raised anything ourselves in our submission or in previous discussions with AUSTRAC. What we have suggested is where we see emerging risks, and AUSTRAC is usually very good at doing this, about engaging with banks through the various forums that they do to talk through these risks well in advance of looking at exercising one of these powers. But again, the powers are very broad, and we do believe appropriate checks and balances should be there, and that's why we're glad to see the consultation with other regulators, the consultation with the public, and a mechanism for review by Parliament through disallowance are appropriate measures in considering the use of such broad powers. So I don't have any specific examples for you, but the reason why the powers need to be broad is that the risks are changing and the techniques used by scammers, by money launderers and others moving illicit proceeds change, and so there needs to be a little bit more flexibility in the way those powers can be applied, which we feel in this case is appropriate.
Okay. I guess is it clear to you what sort of high risk means in this? Like, are you aware of a clear threshold? Like, do you know? Is there anything sort of clear? I mean, it's probably a question for AUSTRAC, but like, obviously, you're part of the, financial ecosystem. In your reporting, would you know what would be classed as high risk if this legislation were to proceed?
We don't have a fixed view on what would constitute high risk, but as you will have no doubt seen in the AUSTRAC submission in public reporting on what they've actually seen people are using crypto ATMs for, I think that is the clearest example of a high-risk activity that warrants AUSTRAC intervention. So,
yeah, sure. Okay. That's it from me. Thanks, Chair.
Thanks a lot. Now, I've just got a few questions I'll ask you to, Mr. Taylor. Just looking at your submission, and thank you again for both your submission and providing further information to members of the committee. Your submission suggests, as I read it, screening persons acting on customers' behalf does not meaningfully contribute to the anti-money laundering or countering terrorism financing. Given that the activities often involve intermediaries, like we've seen with Iran and other countries in our region. How can you be confident that not screening persons acting on behalf of customers won't increase risk?
I think there's a couple of things to think about in responding to this, Chair. The first is a lot of these measures have been to implement FATF requirements, and FATF recommendation 12 does not require these additional steps. So that's the first point that I would make. Secondly is we think that the PEP and sanctions checks should either be done together or not, and in this case the PEP arrangements have been removed, but the sanctions requirements have not. And thirdly, a key principle of the way anti-money laundering and terrorism financing laws operate is on a risk-based approach. The fact that someone acts as an agent, for example, doesn't instantly mean that is more risky, and requiring that check to be undertaken for every scenario where someone acts as an agent, we don't think is proportionate nor consistent with the FATF requirements. So that's the reason why we've suggested that where persons are acting on someone else's behalf, given that the change had already been made to removing the requirement for PEP screenings, we think it would be consistent with FATF requirements and a proportionate-based approach to also align that and remove the sanctions check as a mandatory obligation.
And not to sort of go back over old territory or cover anything from the opening statement, but can I just ask you the basic view around cryptocurrency, or crypto ATMs, I should say? Like, what are your views around crypto ATMs?
I think the most compelling insight into them has been, one, they have exploded in number. You don't go into a convenience store without seeing them. They are in convenience stores, in fuel stations. You're seeing them in broad number in the community. And secondly, the usage data is completely at odds with the type of people who would normally use and purchase cryptocurrencies and digital assets. So if the top 100 users of these products have predominantly been found by AUSTRAC to have either been scammed or acting as money mules, that is clearly a very high-risk activity. And given that they charge very high fees, we don't see a legitimate use case that warrants that warrants them remaining in the community with no effective regulation or oversight. Chair, I think these are not just statistics; these are individuals losing their life savings through targeted scam activity. When AUSTRAC first released this data, I believe in an AFR report, they talked about an 85-year-old woman who had physically fed in, over the course of a year, $325,000 of her life savings. But that is heartbreaking. So again, if this is the type of harm that is presenting itself in the community, there is clearly an issue that needs to be addressed here. And we have no further insights or data. These are operating entirely outside of the banking system, but we think this is a very appropriate case warranting the use of this new power.
And I don't know if you've got a response to this, but do you have any intelligence assessments or understanding of intelligence assessments about crypto ATMs, like what they are, being used for? I mean, do you see them having any legitimate business use here in Australia?
I don't have any, but I personally have access to that information. No doubt my banks, who do through several forums, share information and intelligence with AUSTRAC. They may have some more additional insights, but I'd suggest that's probably a series of questions best directed to AUSTRAC.
I guess my next question then would go to, and I know Mr. Lex will ask them around risk, but what are these sort of risks that the ABA has identified in relation to these products? I think you mentioned, a bit earlier, they can be placed anywhere, these ATMs. They don't necessarily have to be placed in a bank like most of your members would. But, I think, are there any risks like that you see from these ATMs?
Absolutely. As you may be aware, the banking sector has stepped up considerably in the last few years in the fight against scams. We have implemented a scams accord, which is a series of minimum requirements that apply across every bank in the country for actions that they can take to help keep their customers safe. But banks only control one part of the picture. They don't stop scams coming to consumers, which is why the new scams framework that government has implemented is so important at stopping scams from reaching customers so that they are reduced or shielded from the risk of scams. And importantly, if a customer is scammed, it's important to try and, we describe it as stopping the getaway vehicles for where those funds go to. Now, when a customer requests their bank to make a payment, banks have some ability to control or monitor where those payments go. What we're talking about here is an ATM where you physically feed in cash. You pay exorbitantly high fees for exchanging that to a cryptocurrency. And again, AUSTRAC data shows that the main users of these ATMs are people who are either money mules or they have themselves been scammed. This is not an issue that's limited to Australia. I think there's been an explosion in crypto ATMs around the world, and other markets are also dealing with these issues. In Canada and the United States at the moment, they're also looking at this because they are seeing the same type of consumer harms of particularly older and more vulnerable populations losing their life savings to scams, being directed from a remote country to put their life savings into one of these crypto ATMs. And once it's in a cryptocurrency, it's virtually impossible to get back. So that's what we're seeing. We view this as an important community safety measure in the broader fight against scams, and certainly I think this is a very worthwhile area for further AUSTRAC action.
And it sounds to me, from what I've read from submissions and elsewhere, that a lot of these ATMs just happen to be placed in a lot of these tobacco shops. I guess there'd be some concerns from your end too, that unlike banks who are quite heavily regulated about where the ATMs can be placed, that a lot of these ATMs that are connected to crypto are connected to tobacco or vaping stalls that might then be connected to other criminal activity?
I don't have any data about whether that increases or decreases the risk. What I would say is they're certainly very prevalent in the community. In the building I'm working in right now, in the convenience store in the ground level, there is a crypto ATM. Around the corner, there are two more. They are everywhere now. They have exploded in number. The case of the unfortunate 85-year-old woman mentioned in that AUSTRAC reporting, that location did happen to be a tobacconist. I probably am not able to speak to whether or not that increases or decreases the risk. What we would say is there are too many of them, and the legitimate business use case does not seem to be apparent. And so that's really where our concern would come from, Chair.
And not being able to identify who's putting cash in and who's taking cash out. I'm assuming a normal ATM, a traditional ATM, that information would be collected, I'm assuming? You
usually you can really only use a normal cash ATM associated with an account. That account would be for a financial institution, which would have AML and know your customer requirements. And so all of the checks and balances that exist in the AML regime are there. This certainly exists outside of those perimeters and probably does increase the risk. But again, the data from AUSTRAC is showing that the people mainly using this are ones who are being exploited, harmed. So,
yeah, well, we'll have AUSTRAC in the department a bit later on. Look, very quickly, in your submission, you also provided some feedback on the safeguards included in the bill. I guess, as we've discussed, the harms that are caused by high-risk products like crypto. What do you think are the appropriate balance for getting those safeguards right? And what do you see also as those safeguards?
I mentioned the three that have been included in the bill, which we think are very helpful. In our submission, we mention a few others. We think the primary concern or issue here is around remittance or virtual asset providers, and we think that's where the focus and scope of this power should be directed. ADIs or traditional banks are supervised by both APRA and ASIC, and we think that the power is best directed to these new forms where there's certainly higher risk. The second one, I think, is a merits review. ASIC has a very similar power a product intervention power which is also subject to a merits review. We think in this case, if AUSTRAC has a compelling case, and we think ATM providers certainly are, that decision should not only be subject to parliamentary scrutiny, but also the possibility of a merits-based review in the Administrative Appeals Tribunal or a similar body. If the decision is justifiable, then it would no doubt stand up to that scrutiny, but we feel that's an additional important protection that could be included as a check and balance on these powers.
Okay. Well, my final question then also goes to the concerns, or do you have any concerns with the amendments to the definition of financing of terrorism? What will this change mean for banks in practice?
We view this as purely an alignment issue with FATF requirements and changes to the criminal code. So really have no concerns there. The only other comments that we had, particularly in relation to the more technical amendments on the bill, relate to the definition of senior manager. Conscious that because of very recent changes to AML laws and the expansion of AML obligations to new sectors, the department has tried to focus on ensuring that the person who's designated as a senior manager is indeed a senior manager. In large, complicated institutions, however, it might be more appropriate to have someone who's more directly connected with their AML and KYC and AUSTRAC requirements rather than a senior executive. And there may need to be a bit more flexibility, particularly for very large and very complicated institutions, to ensure that that person is a senior manager and appropriately connected to risk responsibility in the organisation. So I think it's just a mismatch between trying to make sure you're getting a senior enough person for a small organisation that's included in tranche 2, but ensuring that the definition actually still works appropriately within a large and complicated financial institution.
All right, well, thank you very much for that, Mr. Taylor. Thanks for your appearance today. If you've been asked to provide any additional information, could I ask that you do so by midday on Monday, the 15th of June, and we'll also send you a copy of today's transcript.
Thank you.
Now, we'll suspend and we'll get ready for our next witness. Thank you. Yep, excellent. Okay, I now would like to welcome representatives of the Law Council of Australia to give evidence at this public hearing today. Could I ask for the Hansard record, could you all please state your full name and the capacity in which you appear today? And I'll start with you, Elizabeth.
Yes, Chair. My name is Elizabeth Shearer. I'm President-elect of the Law Council of Australia.
And who do we have next?
Hi, I'm Pip Bell. I am here as a member of the Financial Services Committee of the Law Council of Australia's Business Law section.
Hi, I'm Sinead O'Brien Butler. I'm a senior policy lawyer at the Law Council of Australia.
All right, thank you. Now, although the committee is not required to give evidence under oath today, I should advise you that this hearing is a legal proceeding of the Parliament and has therefore the same standing as proceedings of their respective houses. Giving false or misleading evidence is a serious matter and may be regarded as a contempt of the Parliament. Giving evidence today will be recorded by Hansard and attracts parliamentary privilege. Now, can I ask, did either of you or did yourself, Elizabeth, want to make an opening statement on behalf of the organisation?
Yes, we do have an opening statement, Chair.
Okay, please proceed.
Thank you. The Law Council of Australia welcomes the opportunity to appear before the committee in relation to its review of the Anti-Money Laundering and Counter-Terrorism Financing Amendment Bill of 2026. In opening, I'd like to, on behalf of the Law Council, acknowledge the traditional owners and custodians of the land from where we're joining today and pay our respects to elders past and present, and extend that respect to all Aboriginal and Torres Strait Islander peoples who are in attendance. The Law Council and its constituent bodies support efforts to combat money laundering and terrorism financing, and we're working tirelessly to ensure that the legal profession understands and guards against the vulnerabilities to financial crime that it may face, particularly in this lead up to the commencement of Tranche 2. But before discussing the substance of the bill, we do wish to express our serious concern that many Tranche 2 reporting entities will not be able to or will face extreme difficulty in attempting to comply with the legislative regime by its commencement on 1 July, just weeks away now. Not enough time was given to the regulated population to prepare for compliance between the passage of the reforms in December 2024 and their commencement, especially given that Tranche 2 entities have never previously been subject to AML regulation. This difficulty is compounded by a lack of clarity in the legislation, so that many legal practices, even at this late stage, can't ascertain whether their services come within the definition of designated services in Table 6, Section 6.6b. The categories are broad and the scope of the exceptions are unclear. We've repeatedly called for the commencement of all, or at least certain parts of the reforms, to be delayed until 1 July 2027, or alternatively, and at the very least, we've recommended that AUSTRAC implement a transitional compliance period of at least 24 months after 1 July, during which it will focus on education and assistance rather than on pursuing compliance through enforcement. We've also repeatedly called for urgent amendments to the Act to clarify the scope of its application, and the amendments we are considering today unfortunately don't respond to those calls. We'd like to take the opportunity to urge the committee to make recommendations in your report for further amendments to address these concerns. So turning then to the substance of the bill itself, we do not support conferring the AUSTRAC CEO with the power to restrict or prohibit a reporting entity from using a product, service, delivery channel or thing to provide a designated service. We don't consider it to be risk-based, proportionate or demonstrably necessary, and we think it would constitute an inappropriate delegation of legislative power. It's the role of the legislature, not AUSTRAC, to decide which designated services can be provided and how. Our concerns are heightened by the fact that it could be exercised in relation to the Table 6 professional services, meaning it could conceivably be used to limit or prohibit the provision of legal services, which, if that were to occur, raises serious rule of law concerns. We also do not support amending the definition of financing of terrorism. Doing so will extend the scope of the legislative regime's obligations less than a month from the commencement for Tranche 2 entities and after they have commenced for Tranche 1 entities. The impact of this is that reporting entities will need to broaden the scope of the term of when fulfilling their AML CTF obligations, including when preparing their risk assessments and in developing policies. This will introduce additional and significant uncertainty and complexity to the regime. Our concerns are heightened by the broadly framed, uncertain scope of the new state-sponsored terrorism offences, which may create practical difficulties for reporting entities in ascertaining the scope of and operationalising their obligations under the legislation. And finally, as to the amendments in Schedule 3, we've concerns regarding Item 3, which will change the ongoing customer due diligence requirement in paragraph 32C1 by exchanging the subjective trigger for the requirement to be an objective trigger. Currently, this paragraph requires reporting entities to review and update Know Your Client information about customer, about a customer if they have doubts about the adequacy or veracity of such information, meaning that it hinges on the reporting entity's subjective knowledge. Item 3 would change this to require this KYC information to be updated if there are reasonable grounds for for the reporting entity to doubt the information's veracity or adequacy. This is an important change, and it's not explained or justified in the explanatory memorandum. We're concerned that it risks exposing reporting entities to sanction in circumstances where they have no way of knowing that objectively reasonable grounds exist that would have, if known, led them to doubt the adequacy or veracity of the KYC information. It will also involve potentially significant cost and administrative burden. Tranche 1 entities have had to comply with the current version of this requirement since 31 March 2026. So if it's changed, they'll need to change their compliance systems, as will any Tranche 2 entities that have already designed their compliance systems. On the whole, our position is that the bill should not pass, and alternatively, we urge you to recommend that it be amended in respect of Schedule 1 to limit the power to registrable designated services, which are remittance and virtual asset services, introduce stronger safeguards and procedural protections, delete Schedule 2 and delete Item 3 of Schedule 3. I refer to our written submission for further reflections on the bill for the benefit of the committee in its scrutiny role, and thank you for the opportunity to appear, and we look forward to responding to your questions.
Okay, thank you very much for that. I'll hand the call over to Senator Cash.
Thank you very much, Chair, and thank you for that comprehensive opening statement, but also for the work that was put into your submission. It was greatly appreciated. I'm just looking at page 7 of your submission, and in particular, the comments that you made in relation to the lack of clarity around certain definitions. And at paragraph 31, you state, nowhere is any explanation given about the intended scope of meaning of the term assisting in these paragraphs. And you also obviously raised that in your opening statement. And that is obviously of concern. Are you in? Are you out? What is in? What is out? In particular, given if they do commence shortly, that, as you've articulated, you could be subject to penalty for non-compliance. If you had to provide that further guidance so that people providing the services are able to comprehensively say, yes, I am in, no, I am out, and you actually refer to it at paragraph 32 as a critical failing to be able to work out if you are regulated by the Act or not, how would you do that? If you could give us some guidance as a committee to potentially make a recommendation.
I guess our point is that the legislation as drafted is very vague and wide. And so we really acknowledge the efforts of AUSTRAC to try and make an operational system for the newly regulated entities. But from a legal practices perspective, the Table 6 services, if we take, for example, the item about holding money in trust accounts. So it's a broad provision. There are some exceptions, but the scope of those are a bit vague, and how they interact with other exceptions are quite difficult. And I think the important thing to understand is that most people don't understand that most legal practices in Australia are very small businesses.
And the rural and regional in particular. Exactly. Yes.
Exactly. So I think maybe 90 of us are in my category of 4 or fewer lawyers in our firm. We're struggling with meeting our compliance obligations because we do share the objective of AUSTRAC that we not be unwittingly used to money launder or finance terrorism. So we share that objective. But it's been very difficult for practices to work through. So am I in or am I out? So conveyancing services in, but at what stage and where is it around the edges of that? And so AUSTRAC has introduced guidance, but that guidance is doesn't have the force of legislation. It's like, how can we make this workable? So they've got their who principle and their when principle. And you work through all of that And we think there are still unanswered questions, like, is a notary public somehow delivering a designated service, which we think clearly that's not the intention, but it's a reasonable interpretation of the legislation. So we think this needs to be addressed at a legislative level.
Yep.
And, you know, three and a half weeks out from compliance, legal practices are still unsure whether they're in or out. For my practice, for example, if we stop conveyancing, then would we be in or out? I mean, clearly, if we do conveyancing, we're in. That's quite a difficult question to answer in terms of how does it impact on our probate and estates practice?
Yeah.
What about our family law practice? There are some exceptions, but not others. And so I think compliance is most likely and most effective where the regulated entities understand what our obligations are and can comply with them. And we think for that to occur, there needs to be legislative amendment, as we've outlined in our submission. And, so while AUSTRAC has done the best that it can in the circumstances, and we've worked closely with them and we're very appreciative of their efforts, it's not really their job to be trying to fix by regulatory guidance legislative problems.
That we as a parliament are able to do. Can I also ask then, in terms of if it's not fixed, and certainly that is something I think the committee does need to give consideration to, just looking at, again, page 5, paragraph 19, but you also did refer to it in your oral submission. It is very much your submission that if the bill is to pass, the tranche 2 reporting entities do still need to be given that additional period of time to actually ensure that they are compliant. If they have to comply, they want to comply, but asking them to do it in 3 weeks is actually asking a lot. Whereas if we could give them a lead in time, that would actually assist potentially to also work through some of these issues.
Yes, exactly, Senator.
Yep. Could I also ask, should the bill require provision of more substantial evidence and more detailed reasons than it does now in relation to the use of AUSTRAC CEO's new powers?
We say yes to that, but I guess we've got a threshold concern as well, which is what this power is effectively banning a whole delivery mechanism. Now, there may be circumstances in which it's entirely appropriate for delivery mechanisms to be banned, but again, we think that's a decision that belongs with the Parliament and with broader policy consideration than with an regulator of money laundering and terrorism financing. So we're not disputing the concerns about crypto ATMs that were raised by the previous witness. So obviously serious concerns, but is it the job of the AUSTRAC CEO to ban a whole service delivery mechanism, or does that require a different level of policy consideration? So that's our threshold concern. And then the second point is, well, if there is to be this power, then it needs to be clearly defined, constrained and subject to appropriate review, as we've set out in the submission.
So that would then go into my second question. If they are granted the various new responsibilities and powers that are contained in the legislation, so it goes through as is, if I go to your submission, but perhaps you could just articulate some for the Hansard record for the purposes of the hearing, the kinds of review and reporting structures you see would be essential in actually managing or helping them to actually manage this. And as a minimum, and I put this to Chris Taylor, I don't know if you heard, would a statutory review within, say, 12 months of the commencement be appropriate as part of that?
I would think so. I think it's not something that we've raised directly, but it's certainly not something we would oppose. Pip, do you have any view on that?
I mean, yeah, it's quite common these days to have statutory reviews within a relatively short space of time of commencing new legislation. My only comment about a 12-month period is I guess we do not know how often AUSTRAC might actually use the power in practice, and so would we have enough test cases after 12 months? And I guess while our submission sort of focused on the fact that we thought Parliament was better served to have such powers, there are some good points made by the ABA about if the regulator is granted such powers rather than the Parliament, the sorts of checks and balances that should exist, and references to having disallowable legislative instruments and scope for judicial review, better alignment with ASIC's product intervention power. That certainly would not go astray and would improve the sort of the accountability, if that's the direction that the Parliament chooses to take on this.
Could I ask then as well then, would you support a requirement that AUSTRAC publish a statement of reasons for the application of each instrument, subject to any essential redactions that would have to take place?
Yes, I think we would consider that a statement of reasons is appropriate, in line with the other review processes. So
yeah, as I said, you put in your submission as well a number of issues that we need to consider. But yeah, I'll keep moving through because I know that we're going to be short on time shortly. Is the Law Council's position that the term significant harm should be specifically defined in the legislation? And if so, as a minimum, how would you do that?
It is our position that it should be better defined, that the scope of this power should be more clearly defined, as well as words like harm, as we've referred to in our submission. We think it's difficult as to what the solution is. I'm not a parliamentary drafts person. I don't know whether Pip or Sinead have views on that.
I mean, certainly there's a similar concept in the privacy legislation supporting the notifiable data breaches. There's a delicate balance between having a sort of principles-based definition and having clarity on the other hand, and given. And it's hard to future-proof when you're preparing legislation. Completely appreciate that, and we don't know what sort of future methods of possibly inflicting harm might exist. But I guess that, and I'm not a privacy law expert, but familiar enough to know that that's a test that's used in the privacy legislation, and I guess having relatively consistent frameworks across different pieces of legislation, which a reporting entity needs to comply with. Would be helpful. I guess generally as the Law Council, we do like to call out unnecessary the need to avoid creating unnecessary complexity, and then when there are lots of different tests used in different pieces of legislation, that does make it very difficult for the regulated population, and for AUSTRAC, that's about to become a very rapidly growing population with a range of sizes of businesses with various degrees of sophistication and resources.
3 more very quick questions, if I may, Chair. In terms of best practice operation of the law, should affected businesses have a statutory right to respond before any determination is made under the proposed legislation?
Could you give an example of what you might consider that would work. I think certainly, well, I think in terms of enforcement, we would anticipate what we think best practice would be an approach that encourages compliance, that raises informally issues, and that enforcement is then only a last
at the end
resort.
in the end, that you can't actually in the first instance work through potentially, because as you say, if it begins on the 1st of July 2026, it may not be deliberate.
Yes. So compliance will come when people understand their obligations and can meet them. Enforcement is a necessary tool at the end, but there's got to be a balance. And what will achieve the policy, of compliance is the support and the carrot end of it, with the necessary stick there, but very much at the end of the process.
Very briefly, from your reading of the bill, are there dangers here that AUSTRAC could use the powers if they wanted to, merely as new enforcement shortcuts, without, as we've just discussed, that ability for businesses to work with them?
Well, when you look at it's good that there's a consultation requirement, but the consultation requirement is to publish on their website, and then 30 days later they're taken to have consulted. So there is that potential, I would say, given that it sets up a system by design, I think, to work quickly because it says it's responsive to emerging needs. But as it's currently drafted, is that capable of the regulator gathering in the information they might need to make these decisions? We think not, and we've recommended longer consultation periods and, other safeguards. I'm not sure whether, Pip, you want to
that's you've just hit my last question. I know it's in the submission, but for the purposes of this hearing, is there anything that you need to put on the record by way of additional safeguards that you want the committee to actually hear, so it's on the Hansard?
Well, I think in relation to review of the decisions, we would say there should be merits review. There should also be judicial review, and we do share the concerns of the scrutiny committee in relation to the non-invalidity point. Effectively undermining the scope of judicial review. And then, of course, it's essentially a delegated legislative exercise, and so should also be subject to scrutiny by the Parliament.
Thank you very much, Chair. And as I said, you've got a very comprehensive submission there also to provide us with guidance, so thank you very much.
Thanks, Senator Cash. Just wanted to ask, just following from Senator Cash's a question there. So was there a reason why you didn't put in an ask of why or when a stat review might occur, or have one at all?
I don't know that there's a particular reason. I mean, generally we do support the notion of a statutory review.
Yeah, that's why I'm asking.
Generally, we've found that the statutory reviews often end up being negotiated in the parliamentary process as a sort of a compromise to getting legislation through, where there will be there'll be an amendment saying that there'll be a statutory review 2 years or 3 years down the track. And I guess in our submission, we focus on what we think is the best and proper outcome. So we address sort of what we see as the shortcomings and why we think that amendment shouldn't be made, rather than sort of thinking about all of the sort of possibilities of how if the amendment was made. But that's if we were asked a specific question as part of the consultation process, it's something we would have turned our mind to. But I guess a statutory review is also just something that occurs once at a point in time. And you've got to think about the ongoing operation of the legislation and making sure that there are appropriate checks and balances, and that sort of protects the regulator as well as the regulated population. We need to protect the integrity of our democracy and our institutions of government and how things work. So and I mean, I don't often see statutory reviews which kind of result in fundamental reform either. Often it is just a bit of a ticking a box saying, yeah, everything's okay, maybe tweak a few things here or there. So we're not against it. I'd hasten to add we wouldn't think it's the be all and end all.
Okay, so you don't. Okay, just in terms of the what you just mentioned just a bit earlier, I wanted to ask if there are any mechanisms that you would suggest that we look at or think about in terms of protecting potential victims of crime and scams during extended consultation and compliance processes.
I think that your question goes to part of the difficulty with this power. It's not essentially a consumer protection power. I mean, while there's a consumer protection need, that's one aspect of the crypto ATM issue that's been raised. But that's not the essential interest of AUSTRAC. AUSTRAC's job is to stop money laundering, not to protect consumers. So the idea of banning a whole delivery mechanism is, I think, a complex policy issue that involves money laundering considerations. It also involves consumer protection considerations and sits within a wider ecosystem of how the community is protected from predatory practice. That's why we essentially think it's not a power that belongs with the AUSTRAC CEO. It's a power that belongs with the legislature to, as a policy, on a policy basis, work out what's the best solution to this problem that has money laundering components and consumer protection and exploitation of vulnerable consumer components. And that's why it needs the broader expertise than just coming from the AUSTRAC CEO making those decisions. So I guess that highlights our concern, but I'm not sure if I've answered your question.
But is it not the case that the AUSTRAC CEO would be the best person because they have the ability to access information in real time rather than us politicians in Canberra, and also having the relationship to talk to folks like yourself and others in the impacted sectors? I mean, if something's happening in real time, I would imagine, I don't know if you heard from our earlier witness from the ABA, but people being scammed is a serious threat. But equally, people who are sponsoring terrorism in this country is equally a serious threat. And I would have thought that maybe the CEO or a person, in this case being the CEO of AUSTRAC, might be the best person to do that job, acknowledging that maybe the Parliament does, at some point review how things are tracking. But putting that to one side, I think it would be better for a policymaker person in Canberra to be making those decisions. But I'd be interested to see what your thoughts are, because it can be very multi-dimensional and very complicated. On one hand, you are trying to protect consumers, but at the same time trying to make sure that people aren't using things like crypto, for instance, to finance terrorism in this country.
I think part of our difficulty, Chair, is that where a regulator wants this power, it should be demonstrated that it's necessary and proportionate. But the only example that we're aware of that's being used in this context is the crypto ATMs. So we can thinking through that process, that seems to be something that's been identified over time as a delivery mechanism that certainly has money laundering concerns. It also has consumer protection concerns. It's a difficult problem that's been identified. While it is something that may need prompt action, it's not in the category of absolutely urgent, must stop immediately sort of issues, because this is something where AUSTRAC's done some research, they've ascertained who's working. It's a process that looks like it's capable of being addressed by an ordinary policy process, not by, I need to make a determination within 30 days to address something that's urgent. So if there were other examples that we could think through how it would operate, then perhaps we'd be better equipped to answer your question. But the only example we've been given is crypto ATMs. That is a serious issue, but it's not in its nature an issue that needs the AUSTRAC CEO to say, put something on their website and 30 days later ban the service, which is what this amendment is about. It seems to me that it's more appropriately addressed in the way it has been, by raising the issue, engaging with stakeholders, and then, a decision could be made about does it need to be banned or not, but whether we don't think that decision belongs with the AUSTRAC CEO. We think it is a complex problem with many facets, and it needs that sort of ordinary policy input to ban a complete delivery mechanism.
So if it's not the CEO of AUSTRAC, then who is it?
Well, it would be ultimately the Parliament to decide what sorts of delivery mechanisms are permitted and what aren't. And,
I guess this is where the Parliament is saying we have a view, government has a view that it should be the CEO of AUSTRAC. I mean, it can't be one of us in Canberra making these calls.
It wouldn't be one, it would be the Parliament collectively to pass legislation rather than one individual.
I don't know if you've been to Parliament often, but I tell you what, trying to pass even some basic...
There are some empty sessions sometimes. I'm aware of that too. And there's sometimes situations where everybody is rushing at the door to get in to make sure they can have their, represent their constituents and have their vote counted. Just with respect to scams and consumer protection, we do have other agencies vested with consumer protection powers, such as the Australian Competition and Consumer Commission and ASIC in the case of financial products and services. And you're probably aware that recently this Scams Protection Framework legislation was passed, and Treasury, I think, is currently consulting on supporting regulations in connection with the Scam Protection Framework. And that involves a number of different industries and giving the Australian Financial Complaints Authority additional powers. And so I guess I would not see this particular proposed bit of legislation as a primary mechanism for combating scams. And I believe that the purpose of the Scam Protection Framework was to ramp up the ability to stop scammers in their tracks and minimise the harm to vulnerable Australian consumers.
Just mindful of time, so I'm just going to ask you a few more questions before I let you go. Look, in your submission, you talk about opposing the amendment of the definition of financing of terrorism. So does the bill, from your perspective, then significantly alter existing obligations, or does it simply extend these obligations to state-sponsored terrorism and offences against the UN Charter?
It's both, I think. So it significantly alters it by bringing in a whole new category of sections from the Criminal Code Act. And what that does is means that for those of us who've worked through our process of how we're going to design our system to comply on 1st of July, we've done it under what the current legislation says. Suddenly there's an amendment that brings in a whole new set of things that we've got to be concerned about. So it's difficult for us to comply with that. It means we have to redesign our system. The new offences are also quite complex. I am not a national security expert, but when they are quite complex, it does sound in real practical terms for regulated entities to have to then go back and work out, well, what does this mean? And so it's not simply a tidying up sort of mechanism, which is, I think, how it's presented. It actually does add substantive new obligations.
And I guess the Law Council does agree, or I'm assuming you do agree, that terrorism is a serious threat, whether it's sponsored by state or by non-state actors.
Absolutely.
Yep. So then
we share the policy objectives here.
Yeah. So then should reporting entities then be less, vigilant to the financing of state-sponsored terrorism than they are regarding, regarding the financing of money laundering or non-state terror financing?
No, of course there shouldn't be. Of course, the policy objective is that we do what we can for our little place in the ecosystem to ensure that we're not used by criminals, whether to money launder, finance terrorism. But for us to be able to comply, we need clarity about what it is we're supposed to be doing. And we think that this input at this stage of an amendment that brings in the state-sponsored terrorism as well makes it really difficult. So from my perspective, well, what does that mean for me? Does that mean, there is only one currently named state sponsor of terrorism. How does that mean I approach requests for legal assistance from people from that country? It sort of raises a whole lot of issues that, at this stage, 3 and a bit weeks out from the start date, just makes it very difficult to know what it is we need to do to comply, because we want to comply. So we think making this amendment at this stage, where people have had to, already regulated entities had to set up their system from the 31st of March. Newly regulated entities have set up our systems to be able to comply from the 1st of July. And then to suddenly change the rules at this point of the game, we think makes it hard for us to comply, not easy. And the objective should be that we've got clear obligations, that we know we can do this and be doing our part. This change makes that difficult for us.
Okay, well, thank you. I'll just check to see if Mr. Luxell had any questions.
Yeah, I do. Thanks, Chair. So my understanding, and I don't see any evidence in the papers otherwise, and correct me if I'm wrong, is that this instrument, if an instrument is made, it would be disallowable by the Parliament. Is that your understanding?
Yes.
Okay.
In terms of the generally delegated legislative power regime, yes.
Yeah. So wouldn't that be the Parliament sort of exercising its power to delegate to the AUSTRAC CEO, and then if there was, for any reason, a reason to disallow it, then the Parliament could also do that? Isn't that a reasonable check and balance on a power like this?
Well, that's how delegated legislation works. But then you look at, it is important what the qualitative nature of that power that you're delegating is, and whether it's appropriate to be delegated to the level of a regulator CEO. We say this isn't, because it's not a routine administrative power. It's a power to say nobody may use this mechanism of delivering services. So we think it's the sort of thing that doesn't belong at that level. It belongs with the Parliament in the first instance. So, yes, the way parliamentary... So I guess it's a matter of what logically should be powers the Parliament reserves to itself and makes legislation to state this is what the law is, this is how you can operate businesses in this country, and what level of power they then delegate to a regulator. And we think this is not appropriate for delegation. So, yes, that whole mechanism of delegated legislation and review is there, but we think this is qualitatively not the sort of power that should be delegated.
So you don't, just to clarify, you don't have an issue with the power, you just don't like that the AUSTRAC CEO has it delegated to them?
Well, I think we don't have an issue with the government making a decision that some service delivery mechanisms may be so high risk they should be prohibited. So, the legislature, on whom we have all elected, can make those sorts of decisions. What you're doing here is handing that power to say, oh, well, things move quickly, so maybe somebody else needs to do that who's closer to it. And that makes sense, and that's how delegated legislation works for appropriate powers. But we think, because this says this is a power to basically ban whole delivery mechanisms, and it's not clear, what that would mean in practice, we think that's a very wide power to give to the CEO of a regulator. And why?
So speculating here, if the power were reversed in that, the CEO of the regulator would make a recommendation to the minister, and then the minister would make that determination.
That would certainly be much better from our perspective, because then the decision is being made from a rule of law and democracy perspective by the person whom the people have elected.
But if the person who the people have elected delegates that power to the regulator, which is then disallowable, you're saying that's not okay?
Well, we're saying that's perfectly okay for some powers, for some decisions, but we think this is such a broad decision that it belongs higher up the tree.
Right. Okay. I look forward to evidence from others to understand this further. Thanks very much.
Okay, thanks a lot. On that note, thank you very much for your appearance today. If there's anything we've asked you to provide any additional information or questions taken on notice, could you do so by 12 p.m. on Monday, the 15th of June, and we'll also send you a copy of the transcript. We'll now move on to our next witness for today, and that's the Transparency International Australia to give evidence at this hearing today. Hello, Anton. Now, for the Hansard record, could you please state your full name and the capacity in which you appear before today's committee?
Hello. Sorry, Clancy, you go ahead.
Oh, thank you, Anton. Yeah, hi, Senator. It's Clancy Moore, Chief Executive Officer of Transparency International Australia. I'm also here with my colleague who will introduce himself now. Thank you, Anton.
Thanks. I'm Anton Moisenko, Senior Advisor at Transparency International Australia, and I'm also an Associate Professor of Law at ANU. I did put in a belated submission in my academic capacity, but today I'll speak to TI's submission, which, of course, I fully endorse.
Thanks a lot. Sorry about that, Mr. Moore. I didn't see it pop up on my screen. But now, you'd be aware that although the committee does not require you to give evidence under oath, I should advise that this is a hearing of the Parliament and is a legal proceeding of both chambers of Parliament. The giving of false or misleading evidence is a serious matter, may be regarded as contempt. Now, did either of you have an opening statement today?
Yes, I'll read a short opening statement, after which we're happy to take the committee's questions as needed. Yeah, thank you. Firstly, thank you, committee, for allowing us to speak today. Transparency International Australia is pleased to support recommendations, particularly in relation to Schedule 1 and Schedule 3 of the proposed amendments. And committee members, we are an anti-corruption non-government organisation. We're part of a global movement of around 100 Transparency International chapters globally working to combat corruption, but also the harm of illicit financial flows. And we know that for far too long, Australia has been a source of much dirty money from organised crime gangs, corrupt officials, and even kleptocrats from other countries who use our economy to wash their dirty money. And often this money is stolen from local communities and ends up in Australia whilst enriching those actors as well. So that's why we work to combat illicit financial flows, and that's why the changes are so important. Specifically, we support the changes to the definitions of politically exposed persons, but also the extensions of the powers to the AUSTRAC-CO to prohibit reporting entities from using those high-risk mechanisms that you were just discussing earlier. We do know that these changes will support Australia's upcoming assessment under the Financial Action Task Force, which is the global assessor for counter-terrorism financing and money laundering standards. But we'd also stress the importance of another change to increase the transparency of legal ownership through the government's planned beneficial ownership register as well. Just in relation to crypto ATMs and the high risk that's being seen currently, I would reference a 2023 academic study which assessed Australian case law involving cryptocurrency and found a significant number of crypto-related cases before courts, particularly since 2018. Also to note the fact that Australia has the highest number of crypto ATMs in the Asia Pacific. And at the time of our submission, these numbers were increasing to approximately 2,000 crypto ATMs around the country as well. And then just in relation to some of the harms and the evidence out there around the use of illicit financial flows and crypto ATMs and digital service exchange providers, and I quote I cite the research from Transparency International Russia that's had to flee Russia after being named an enemy of the state by Vladimir Putin on a few occasions. Their research showed that hundreds of anonymous money mule accounts were being sold to Russian speakers to facilitate the conversion of cryptocurrency into fiat currency, such as UK pounds or euros. Also that these services, the use of crypto ATMs and high-risk digital service exchanges were used to avoid sanctions, to fund other criminal activities, but also by Russian elites who use these high-risk service to launder money and then move wealth into, in this instance, London's real estate sector as well. And there's also evidence of these services being used to fund spy activities as well. So that's why we support the changes. Very happy to continue the conversation, open questions as need be. Thank you.
Okay, well, thanks a lot for that. I will hand over to Senator Cash.
Thank you, Chair. And I know that we are tight on time, so I'll be as efficient as possible. Thank you, gentlemen. In relation to both effectiveness and proportionality, is it your assessment that annual or near annual reporting to Parliament would strengthen public confidence in the AUSTRAC CEO's new powers? And if so, what should the content of that reporting actually include?
Yeah, thank you, Senator, for your question. I'll also ask my colleague Anton to share any thoughts as well. I think reporting is a good thing. Obviously, Australia gets assessed periodically through the mutual evaluation review process by FATF as the global standard. But yeah, there's always a case for more accountability and more reporting. In terms of how it could work for this legislative instrument and these changes, let's wait and see if that's an amendment. But Anton, do you have any comments to this question that you'd like to share as well?
Yes. I think that the consultation requirements that I understand have been a matter of some contention so far naturally lend themselves to being used for the purpose of preparing a report of that nature. That's to say, the CEO of AUSTRAC can lay out why the powers were exercised, how they were exercised, what consultation was undertaken, and what the intended effect of those powers is. I also note that under the proposed legislation, the exercise of these powers has to be renewed periodically, and that again offers an opportunity for AUSTRAC to stand back and say, are we confident that we still need to exercise these powers? But it also enables them to provide a report of the nature that you are suggesting to Parliament, which on the whole, I would echo Clancy, sounds to me like a very sound idea.
Is there a better way of giving AUSTRAC broader and more effective powers in this area instead of, say, handing it much of a blank cheque as much of parts of the bill seem to do?
I'm happy to start on that. I think it's quite right to say that these are serious powers and they can lead to significant consequences for regulated businesses. However, AUSTRAC is a well-regarded agency with significant expertise to make determinations in the domain of AML, CTF. Ultimately, it is a policy decision for Parliament as to how much Parliament is comfortable delegating to AUSTRAC. But one point that may or may not have come up in discussions so far that I point you to is the international experience in the United States in particular, where there are powers that are not too dissimilar from what is being proposed here. For example, under the Bank Secrecy Act in the United States, FinCEN, which is the US counterpart to AUSTRAC, can impose increased reporting requirements on certain categories of businesses in the US that was exercised in order to put in place so-called geographic targeting orders, which require increased reporting from, as the title would suggest, certain geographic areas within the United States. And separately to that, FinCEN has powers to designate foreign jurisdictions, institutions, or categories of transactions of elevated money laundering concern. So that is the kind of foreign experience that you might wish to look to as you decide on the appropriateness of this very broad delegation.
Thank you for that. That was actually my next question. So you've answered that. So greatly appreciated there, the international comparisons. Should potential restrictions and bans on businesses potentially affected by the legislation be accompanied by a requirement for more detail, including more published evidence and more transparent criteria than is currently stipulated in the bill?
Yeah, thank you, Senator. Look, we would always argue for greater transparency in terms of how decisions are made and information is received. So yeah, we would support greater transparency as a principle. We'd need to take it on notice to kind of just check in with the actual requirements under the proposed legislation.
That would be greatly appreciated. Should Austrac be required to formally evaluate the potential and likely effects of pushing activity into less visible and less regulated channels before imposing restrictions or bans?
Yes, we do note the risk of displacement of illicit financial flows as a growing trend with any form of regulation of the financial system. My understanding, based on the checks and balances, there are pretty strong safeguards already before the Austrac CEO would make a kind of call on it as well. Noting that already Austrac works very closely with the financial sector, banks and other providers, and is in constant, consultation and dialogue with those affected entities as well. So, it's hard to see. Maybe Anton has kind of further comments on this question, but I think the balance is probably right at the moment.
Okay.
Thank you, Clancy. To that question, I note that the current proposed subsection 2 in section 77 capital A speaks to the public interest test that the CEO of Austrac needs to consider. And I think there may be an argument there that the displacement concern that you've outlined is implicitly captured by some of the criteria that need to be considered. For example, the effect of the proposed restriction or prohibition on the harm that is sought to be addressed. But I could also see an argument in favour of specifying that the displacement effect could be one of the considerations that need to be taken into account. One thing that I would caution against, though, is that ultimately those matters tend to be almost impossible to estimate, let alone trying to predict how they will play out in the future. And so one would not want to create too much of a risk of paralysis by analysis, where one is trying to anticipate something with greater precision than is humanly possible.
Thank you for that. Should there be clearer and better distinction in the content of the bill as to how the new powers apply to compliant and non-compliant operators, respectively?
Well, I think that ultimately the test, as I understand it here in the Act, is not so much the distinction between compliance and non-compliance, but the distinction between high-risk services and non-high-risk services. So I suspect what you're pointing towards is what is the position of someone who provides services that might be in the abstract described as high risk, but is keen to comply and work cooperatively with Austrac in order to mitigate those risks. My understanding on the face of it would be that the consultation process would naturally or should naturally lead Austrac to make that distinction between something that can be addressed through ordinary engagement with regulated businesses versus a more extreme situation where the exercise of these powers would be appropriate and indeed required.
Yeah, okay, thank you for that, which goes back to obviously how important the consultation actually is. From your reading of the bill, are there dangers here that Austrac could use the new powers if it wanted to? We're not saying that they would, but based on the way the bill is drafted, if it wanted to, as new enforcement shortcuts?
Look, I think it's genuinely difficult to answer this as a hypothetical because so far Austrac has been, I think it's fair to say, internationally well regarded for its approach to enforcement, which has been sound and has been in some way going from strength to strength, first as relates to banks, now as relates to casinos. So the only answer that one can really give to this is one would hope not. And there are certainly safeguards that are sought to be incorporated into the Act, including the consultation to ensure that the risk that you outline does not materialise.
Okay. As a general principle, should there be enhanced due diligence mechanisms for transactions linked to designated high-risk jurisdictions?
I think my understanding, and Clancy might add to that, but my understanding is that that is already required under the AML-CTF Act as it currently stands, where businesses need to take a risk-based approach. And so if one interacts with a high-risk jurisdiction, whether, for example, it's blacklisted or grey-listed by the FATF, or potentially a regulated business themselves come to a conclusion that a particular jurisdiction is higher risk, then they do need to apply enhanced due diligence. That's my understanding.
Yeah, just to add to Anton's comments, Senator, they are already in the current legislation, but it's also a proportionate-based process by the entity. So, the requirements on a small legal provider or a small real estate agent would be very different to a large banking or financial institution based on their profile and size.
And just circling back, you were giving the example of the USA by way of an international comparison. Is there anything else that you think we should look to, and in particular lessons that Australia can best draw from other jurisdictions that have restricted or banned crypto ATMs?
Well, I realise that New Zealand has taken that step, so New Zealand would be the obvious answer. Now, that relates, I suppose, specifically to the example of crypto ATMs. The US comparator is interesting in that it speaks to how these kinds of powers can be cast, and there are slightly different models. So what is now being proposed is not quite what the US has. It's different. It's not to say that it's better or worse, but I think there is an interesting question of what are those international comparators. I haven't done any research into that in preparation for this beyond the US. That's an example that came to mind. So it would not surprise me if there were, in fact, other jurisdictions around the world that have something of a similar nature.
Yeah, we're happy to take that question.
Oh, sorry, thank you.
We'll take that on notice and get back to you, Senator.
Brilliant. Okay. Thank you, Chair, and thank you, gentlemen.
Thank you.
Thanks, Senator. Look, I'll just ask you a couple of questions. In your submission, you spoke about the growing issues with the cryptocurrency-related crimes and crypto, I think fiat currency providers. Are you able to expand on that for me, please?
Sure. I mean, Anton can also add from his wealth of experience. And so the research that I referenced at the start of the inquiry, Senator, talked about some research that Transparency International UK and Transparency International Russia had done, where people had used crypto to fiat exchanges, so basically exchanging crypto to cash, to use and then basically wash that resources and then invest in real estate, but also espionage in a couple of cases as well. So that's a pretty common kind of way of using those services to launder money, wash money into actual cash, and then use that cash for other purposes as well. But Anton might have some Australian relevant examples. Otherwise, we can take them on notice if need be.
I think just one point, if one thinks from first principles, then cash, of course, is anonymous. So that's one of the points of appeal of cash to a criminal clientele. Cryptocurrency, depending on the specific crypto and depending how the payment is effectuated, may also be anonymously transferred, but that would happen internationally across borders. And so crypto ATMs are where the two worlds meet, physical cash and cryptocurrency, and that accounts for a significant risk profile of those ATMs. There is, of course, the point that was adumbrated by Senator Cash of could you deal with that through regulation and engaging with, for example, crypto ATMs or other cryptocurrency service providers to mitigate those risks. So that's an approach that I suspect everyone would agree should always be the first port of call. But clearly, in Australia, there's been a particular concern around crypto ATMs as expressed by Austrac.
Do you have a sense of who owns or operates these type of crypto ATMs?
I don't know.
Do you have any understanding of intelligence assessments that about? I mean, you mentioned about that example about people having cryptocurrency being able to withdraw cash. I'm assuming the reverse happens. People can put cash into the system.
Yes.
In terms of checks and balances here, I mean, it's quite possible that crypto is being sent across the world from countries like Russia, North Korea, Iran, coming into Australia potentially to finance terrorism or other activities of that kind.
So I'm not privy to the intelligence assessments, although I understand from the speech by the Minister for Home Affairs who introduced these proposed powers some time ago that Austrac has prepared an intelligence assessment that demonstrates a rather staggering amount of criminal use of crypto ATMs in particular. If one zooms out and asks about the general types of the criminal exploitation of cryptocurrency, you're right that it's varied, it's diverse. Organizations like Chainalysis, Elliptic, and TRM Labs prepare annual reports on the various types of cryptocurrency-related crime. It involves, as you've rightly indicated, sanctions evasion, as well as multiple categories of criminal activities. One could also say the same of cash in the traditional financial sector, but there's certainly a wealth of criminal risks in crypto that need to be addressed.
Mm-hmm. I guess unlike the banks, which are heavily regulated and have a better sense of money, both cash and electronic currency being transferred, there is virtually little I think, scrutiny or oversight about what happens in the crypto world. And I guess some of the evidence that you've provided to the committee today suggests that it is hard for governments around the world to understand who is moving this money around and where it's originating from.
In principle, the level of oversight has to be quite similar to the traditional banking sector in that under the FATF recommendations, and the FATF has been name-checked a number of times today, crypto asset service providers need to be regulated by countries in the same way, essentially, as banks. Very similar requirements as relates to customer due diligence, suspicious matter reporting, record keeping, international value transfer reporting, and so on. The added layer of complication in the world of crypto is that a bank would ordinarily be incorporated and would have brick and mortar offices in your jurisdiction. So you can go and knock down the doors and seize documents and look at what's happening. This might
to verify.
Yes, this might or might not be available in relation to cryptocurrency businesses. So the conceptual framework of regulation is similar, but it is true that there are unique challenges stemming from an international and somewhat disembodied internet-based nature of the operations of those businesses.
So it's quite possible, though, that people who have been sanctioned, we sanction people, other countries sanction people, those people could be providing funds, not legally, but through crypto as a means of sponsoring terrorism in this country. Is that something that you would agree?
I think it's possible. They might be a little bit more sophisticated in the way they go about it. They might sort of employ a kind
simplifying it for the purpose
shell company that has a particular crypto wallet. But yes, absolutely. Yep.
Yeah, and I think that's the danger that crypto presents itself. There are, in theory, the same checks and balances, but in practice, because of the way it's set up, in practice, crypto, in some ways, has almost living in this sort of Wild West arrangement, unlike what the banks are doing, and making sure there is integrity in the system.
Yep. Yeah, and I would hasten to add that's why I think this legislative change is important, but also noting the upcoming Financial Action Task Force review that's already started. But I think there'll be an in-country visit by the assessors later this year. So it's important not only for reducing harm, but also Australia's reputation that these changes are progressed, speedily.
And just very quickly, are there any other high-risk services or products you think the government should also examine as a priority?
I would say there was a question in the earlier session as well. What are the other examples? And I think an obvious one to consider would be situations involving high-risk countries. So this is one of the cases where Austrac might wish to exercise those powers going forward. So if you provide a service that involves, let's say, customers or counterparties in a particular high-risk jurisdiction, then other additional restrictions or indeed requirements as to information gathering might be applied. This is, simply speaking off the top of my head, one broad category of cases where a form of increased information gathering powers or the ability to impose additional restrictions might be appropriate.
In your submission, you also mentioned that money laundering often harms the most marginalised people in our society. I was hoping you could provide some examples and just explain this impact on those affected.
Yeah, so it has a sort of justice element, and that's the rationale for Transparency International advocating for greater regulation of financial flows globally. So there is very strong evidence of communities, let's say in Sri Lanka, South Sudan, who have essentially had funds stolen from their national budgets that should be used for services, funding roads, schools and hospitals, stolen by elites, political elites, and then that money being washed through the financial system, often ending up in Australia in real estate, as one example. But similarly, laundered funds, illicit financial flows can also be used to sponsor terrorism and war in some cases as well. So there's ample evidence there. I'm happy to provide further research and take that on notice should the committee...
If you could.
That. Yep.
Because your submission also warns about the risk of displacement and the evolving nature of high-risk mechanisms. And again, if you're able to explain what's meant by this, and if you need to take it on notice too, I'd welcome that.
Yeah, sure. Happy to take it on notice, noting the time is running short.
That's all right. Just finally, gentlemen, how should the updated framework account for these risks?
Well, similar to the point I made in the exchange with Senator Cash, my view is that these kinds of considerations should form part of the deliberation and consultation process that the CEO of Austrac will engage in. And as we've discussed, there are fairly broadly defined criteria there that need to be considered. They are apt to subsume a number of sub-factors or sub-considerations, such as indeed the displacement effect.
Now, I understand Mr. Laxwell has one question, and then we'll break briefly.
Yeah, look, I'll be really brief. It was just in regards to sort of defining high risk. Is there any sort of comment you have on that? Like you've mentioned countries as another example of high risk. Obviously, you've got the crypto ATM, which seems to be more about a transparency thing. Like, is this something that needs to deliberately be fluid for the Austrac CEO to make a determination, or is it something that could be a bit more defined?
Just a very quick response to that. I note that one of the requirements in order for the powers to be exercised is that Austrac needs to consider that significant harm has been caused, will be caused, or will likely be caused by the high-risk products, services, etc. And so it seems to me that that requirement of significant harm constrains the scope for action there to something that, as the term suggests, is quite serious.
And you think that's a reasonable enough restraint on the use of that power?
I would think so.
That was all. Thanks, Chair.
Thank you very much. Now, thank you, gentlemen. On that note, if there are any questions taken notice, and I think there were a couple, if you could please provide an answer by midday Monday, the 15th of June. We'll also send you a copy of the transcript for your review. On that note, thank you very much. Now, we're going to just take a very short break, and we'll be back here in 5 minutes with our next witness, being the Australian Payments Network Limited. Thanks, everyone. Okay, I now welcome representatives of the Australian Payments Network Limited. For the Hansard record, could I ask that you state your full name and the capacity in which you appeared before today's committee hearing?
Thank you, Chair. My name is Andrew Michael Spurway-White, and I'm appearing as CEO of Australian Payments Network, or AusPayNet for short.
Thank you. Now, although the committee does not require you to give evidence under oath, I should advise you that this hearing is still a legal proceeding of the Parliament and therefore has the same standing as proceedings of their respective houses, given false or misleading evidence is a serious matter. Now, the evidence given today will be recorded by Hansard and does attract parliamentary privilege. However, I should note that given that you are overseas at the moment, it does not, unfortunately. But I still will ask that if you're able to provide an opening statement, and then we'll proceed to any questions that senators or members might have.
Absolutely. Good afternoon, and thank you, Chair and members of the committee. I apologise that pre-booked international travel prevents me from attending in person. AusPayNet is the industry association and self-regulatory body for payments in Australia. Our role is to develop and manage standards and guidelines and manage large-scale collaborative transformation programs with the purpose of confidence in payments for all Australians. We currently have more than 160 members, including financial institutions, payment service operators, retailers, fintechs, and payment service providers. In the context of the breadth of our membership, AusPayNet's role is not to advocate for particular commercial outcomes, but to support informed decision-making by explaining how the payment system operates in practice. We welcome the committee's inquiry and the government's review of the AML-CTF regime to ensure that it remains clear, fit for purpose, and meets international standards and best practice. Payments are essential economic infrastructure. They underpin everyday activity for households, businesses, and government. Trust in payments and the wider digital economy is critical for all Australians. We should ensure that Australia is the hardest possible target for economic crime, including terrorism financing and money laundering. The committee has invited AusPayNet's views on the Bulk Electronic Clearing System, or BECS, in the context of the bill, given AusPayNet coordinates the rules and processes for direct entry payments through BECS. BECS is a batch electronic payment system, similar to those in other jurisdictions, and used extensively by financial institutions, businesses, and government for various transactions such as welfare, payroll, direct debits, and supplier payments. AusPayNet acknowledges AUSTRAC's careful and consultative approach in developing these reforms. The bill reflects a considered understanding of how different payment systems function and provides workable compliance pathways for financial institutions. AML-CTF obligations in relation to BECS transactions are borne by the financial institutions in the payment chain. To be clear, those obligations under the AML-CTF Act attach to the reporting entity, not the payment mechanism itself. BECS is compliant with the Financial Action Task Force requirements for the inclusion of mandatory information in cross-border and domestic payments, which recognise that information other than tracing information can be made available to the beneficiary financial institution and appropriate authorities by other means than the payment itself. BECS is also compliant with the amended AML-CTF Act's provisions, which took effect at the end of March 2026, which specify the information to be collected, verified, and passed on in each circumstance. Moving away from BECS, I would also offer two further brief observations on other matters in the bill, namely the treatment of suspicious matter reports, SMRs, and the regulation of crypto ATMs. On SMRs, while they support the detection of suspicious activity, there are structural limitations in their capacity to restrain or disrupt the proceeds of crime. AusPayNet's Economic Crime Forum, or ECF, has established Project Mertoa, a public-private initiative that seeks to develop modern pathways for referrals and restraint of suspected proceeds of crime. AusPayNet would be happy to provide further detail on this work as it develops. On crypto ATMs, AusPayNet strongly supports measures to address the serious harms associated with crypto ATMs and notes that other jurisdictions have generally moved towards their prohibition. We therefore support the intent behind the bill's introduction of a sector-wide mechanism enabling the AUSTRAC CEO to restrict or prohibit high-risk delivery channels and suggest that this should start with crypto ATMs. We appreciate the committee's interest in these issues, and I would be pleased to assist by answering your questions. Thank you.
Look, thanks a lot for that. Senator Cash,
thank you very much, Chair, and thank you, Mr. White, for that submission. Is there a reasonable case that AUSTRAC should be required to consult ASIC, APRA and or Treasury before its CEO potentially uses any or all of the new powers afforded to them by the bill?
I think it's a very good question. I think there is a very good case for that. The way we think about this is that the powers have been introduced for good reason. The previous powers were limited to AUSTRAC acting on individual institutions, and the amended powers under the AML-CTF Act now allow for a market-wide action by the AUSTRAC CEO, which is important, for example, in dealing with something like crypto ATMs. However, it does raise the question as to how you deal with all of the institutions within the chain who are all regulated by others. And therefore, that's why your question is a good one, because quite clearly you need some cross-regulatory coordination in order to actually make that work.
Brilliant, thank you. Should AUSTRAC be required to demonstrate that restrictions or bans on particular non-compliant operators are insufficient before restricting an entire delivery channel?
That's a really good question. I think you will have heard from others that there is a concern from some, and some of our members share this concern, that the powers are too broad. And so stepping through it in that way would be a way of solving for that, in terms of trying to deal with the issue, whatever that issue is, at an individual operator level prior to using the market-wide power that now exists. I think it's a sensible safeguard, and I think our advice, for what it's worth, to the committee would be to think of safeguards that ameliorate that issue.
Yeah, and I think in the second last paragraph of your written submission, you support the bill's introduction and the intent of the sector-wide mechanism, etc., but you also do say, we would encourage the committee to consider whether current drafting is both effective in this regard and contains sufficient safeguards. Can you take us through what other safeguards you see as being necessary? I mean, each witness has raised safeguards, so just from your perspective.
Yeah, so I think, and as you say, you've heard some of this from other witnesses. I think the safeguard that you've just described, looking at individual actors within the ecosystem prior to applying a market-wide power, is a sensible one. I think the level of harm, again, is a sensible safeguard, which is baked into the Act. So it's those kind of things. I think it is worth a review and a bit of a pause to make sure that it is doing what we expect it to do, and so therefore there may be additional safeguards that could be baked in as well.
Okay. Given obviously your extensive knowledge in relation to payment networks, if the AUSTRAC CEO was to restrict crypto ATMs in the way that is stipulated in the legislation, is there then a risk that the criminal activity simply moves on to other payment channels? And if so, what kinds of displacement or transition should we all be most alive to?
So there is unfortunately always that risk with economic crime. People have described it as whack-a-mole, or a waterbed. You push on one part and another part comes up. Whatever analogy takes your fancy. But there is always that risk because the bad actors don't just give up here. They move to where is next weakest. I think, by the way, that is the power in making Australia a hard target. It would be unfortunate for other jurisdictions, but it would at least mean that harm is not heading towards Australians. I think in the case of crypto ATMs, though, there is a difference here because of the nature of that channel. And we've done, I mentioned our Economic Crime Forum previously, where we bring together financial institutions, regulators, and critically law enforcement. We've done some really good work with law enforcement, and that has backed up AUSTRAC's own view that really there's no legitimate use case for crypto ATMs. It is 100% either money laundering or scam proceeds. And therefore, by shutting off that channel, you do make it more difficult for those bad actors, particularly where they're reliant on. And unfortunately, some of the analysis on crypto ATMs is that there is a significant proportion that is older Australians who are depositing monies into those crypto ATMs. If you shut that off, then there's a question as to how could the scammer get those older Australians to actually proceed those funds? So I think there is a real opportunity, and as I mentioned in my opening remarks, it's what we've seen other jurisdictions do in terms of just prohibit that channel, and make it a harder target.
No, thank you for that. Do you think that current privacy, secrecy or competition settings inhibit legitimate financial crime information sharing, and if so, how?
So we have talked about this in other forums a fair deal, and it's not a unique problem to Australia. When we talk with our global peers, there are issues where privacy law or competition law gets in the way of information sharing. I think the way, though, that Australia has thought about that in the design of the National Anti-Scam Centre, in the design of the Scam Prevention Framework, as enablers of the kind of information sharing and actionable scam intelligence, as the Scams Prevention Framework thinks about it, is world leading. We should recognise that. It's more sophisticated than other jurisdictions. But we need to, and for example, we did this in a submission on the last review of privacy law in Australia. We need to continually think about how we enable it. And there are some really good international examples. So Malaysia is the one that springs to mind, where if a financial institution, for example, thinks that a customer of theirs is a bad actor, then it is enabled to share information on that bad actor immediately. So in other words, it thinks there's a criminal in the system. It can share information, and so moving to that sort of respecting privacy law, absolutely, but moving to that bias that you should share if you suspect crime, I think is a reasonable halfway house there.
Just in terms of scam disruption, are there any other lessons from scam disruption that could be applied to terrorism financing detection?
So I think as I say, the setup for information sharing, and I say this sort of in the knowledge that we need to actually implement the Scams Prevention Framework. There's the consultation out there on the codes, but the sectors have been designated. I think reflecting on that as it's implemented could be quite useful. And the other piece that springs to mind is the suspicious matter report element that I mentioned in my opening remarks. Again, that has been a tried and trusted mechanism for decades. Again, it's broadly equivalent to what is done overseas. But it needs to be recognised that it's not particularly efficient actually in restricting the proceeds of financial crime. So again, I think reviewing that and seeing whether there are learnings that come out of the development of the Scams Prevention Framework would be useful.
Okay. In the current framework, or should I say, is the current framework more likely to detect suspicious transactions after the fact than to identify warning signs in real time? And if that is the case, what would most need to change beyond what's in this bill itself for the system to identify those warning signs earlier?
So I think my short answer is yes. At the moment, the system is designed really to capture after the event, rather than in the event. My longer answer is, and it sort of reflects back on your previous question, Senator. I think there are, if you look at the economic crime mitigation industry more generally, then there are pieces where we are getting much better at identifying issues in the moment. So, for example, the Australian Financial Crimes Exchange, with their financial reporting exchange of information, largely targeted on scams and fraud and those sort of items. that is very good at using real-time information. There are some global elements underway, so the signals exchange globally, which again can use real-time information. And so I think your question is a good one, because what we should be doing is not looking at scams and fraud and money laundering and terrorism financing as silos. Cyber risk, I would add, actually. The bad actors don't think of them as silos. They bring them all together as a way of attacking us. So let's do the same and take the best of breed from all of those different developments and apply them so that we can actually, in the case of scams, stop scams at source. In the case of money laundering, counter-terrorism financing, similar.
And just final question, Chair. Does AusPayNet support or oppose enhanced due diligence for transactions linked to designated high-risk jurisdictions?
So we would support that. I think our suggestion there, as with a lot of those kind of restrictions, that it should be a risk-based approach rather than transaction by transaction. And rely on financial institutions and other payment service providers and their skill in applying a risk-based approach to that.
Thank you very much, Mr. White. That was incredibly helpful. Thank you.
Thank you, Senator.
Thanks, Senator. I'll see if Mr. Luxell's online.
Yes, I am, Chair. I've got a few questions, if that's
Fire
okay.
away.
Thank you, Chair, and good to see you again, Mr. White, in a different capacity this time. Apologies for not having the camera on. I'm just a bit mobile at the moment. I guess I just wanted to start just with, I guess, whether or not you think the AUSTRAC CEO is the best person placed to sort of make these determinations. We've heard some evidence that might not be the case. So just sort of from your perspective, as part of the payments ecosystem, do you think they're best placed to make these determinations?
So thank you, Mr. Luxell, and good to see you again as well. So I would think about this in the way that actually Senator Cash did in her first question, in the sense that the AUSTRAC CEO, quite rightly given their role, has certain powers today. Those powers are limited under the old MLCTF Act to acting on individual institutions. The power that is added under the amendments, simply put, allows more market-wide use of those powers, which we support and we think can be quite powerful on high-risk channels, such as crypto ATMs. And as I said in my open, we would encourage action there, similar to what we've seen in other jurisdictions in prohibiting those channels. So we think all of that is sensible. We do think there should be safeguards around that, and one of those safeguards is coordination with other regulators in this space. That's obviously particularly important, we think, in payments, given that some of the institutions would already be regulated by APRA. Some of them would be captured under the Payment System Regulation Act by the RBA, and Treasury would logically have a voice here as well. So we think that's a long way of saying yes, but with some sensible safeguards around it.
Yeah. So I guess what makes them, what makes that role integral in sort of enacting this power? Like, why have they gone with, the CEO? Why is it that AUSTRAC CEO is best placed to do this rather than the minister, for example? Is it the speed? Is it the agility? Is it the information that they come across? Just explain sort of the nature of the payments ecosystem and why that role's identified here. Yes.
So I think the way that Australia has tended to think about this is, rather than create a new regulator or whatever it might be, let's leverage the specific regulators that we have in play at the moment. and AUSTRAC has obviously a specific role within financial crime, which makes it, to your initial question, the right home for this, given their skill sets. To your point about information, although as I mentioned in my opening remarks, we would recognise that suspicious matter reporting doesn't work perfectly. It provides significant information to AUSTRAC in order to make decisions. And also, AUSTRAC is very heavily involved in the kind of coordination activities that I've described as being needed. So it does work with others in the ecosystem, other regulators, but also other entities, including ourselves. So having that sort of demarcation of RBA is about payments policy. APRA is about the regulation of prudential regulation of financial institutions. ASIC is about conduct regulation, etc. Gives AUSTRAC that clean home within the financial crime space.
Okay, thanks. Just going back on some of the evidence you gave to the House Economics inquiry, which is available on Hansard, I guess, for other members here. I'll kind of paraphrase it and like to unpack it a bit more, given that this is probably the more appropriate scene for some of those questions. I asked a question about whether or not BEX was capable to meeting new requirements on AMF CTL rules from the 1st of July. And you said that BEX currently has an arrangement where it doesn't need to abide by those rules. Is that still consistent evidence? Just sort of how does that intersect with the opening statement you gave earlier?
Yeah, no, thanks, Mr. Luxall. I think reflecting on my prior comments, there are two pieces that I didn't explain well enough. So the first was that my response to you then was based on the rules at the time, and obviously the rules were about to change at the end of March, and I could have done a more fulsome explanation of what those rule changes meant at the end of March, and how BEX then complies with those. And as I said in my open, our view on that is that actually it's a much more sophisticated, both FATF and the amendments to the ML-CTF Act that came in March are much more sophisticated in thinking about the different capabilities of different payment systems than the prior arrangements. So in a way that was a timing issue. And the second piece that I think I could have been more fulsome on was being very clear, as I tried to be in my open just now, that the obligations ultimately are on the financial institutions involved rather than the payment system. And the way that both FATF and AML-CTF think about that is, and as I say, in a much more sophisticated way now than they did before, what information can payment systems provide that helps with financial institutions meeting those requirements, and how do they differ depending on whether they're rich data, real-time systems, or like BEX, batch systems.
So is it still the case that BEX has an exemption from these new rules, or there's no need for an exemption anymore?
No, there's no need for an exemption because the BEX is able to comply with both the FATF rules and the new AML-CTF rules. Just to spell that out, so the FATF rules recognise that information other than tracing information, so-called travel information, can be made available to the beneficiary financial institution and indeed regulators outside of the payment. So therefore, there's no requirement on BEX to do so.
And is that information sort of automatic on request? Does it add any complexity to? It's
on request, and it certainly does add complexity. So consistent with our prior discussion in the previous inquiry, we would expect over time transactions to move from BEX to NPP based on the fact that it is easier for financial institutions to meet their regulatory obligations in this space through the NPP's International Payment Service. So we would expect that. That said, there are factors beyond just the compliance with regulatory obligations in play here. Obviously, you know, the NPP has work that it is currently doing around reach. So can a financial institution know that it can hit 100% of its transactions across 100% of accounts? It has work that it's doing around capacity, so volume. There's also capability around bulk payments, for example, batch payments. And obviously the economics need to work. So there's factors in play here beyond compliance as to whether that move happens.
Yeah. I mean, look, this is ultimately a question for AUSTRAC, but again, I'll put it to you. So you're saying the incentive of ease of compliance is one which you believe will push people across from the old tired BEC system to the MPP system. Do you think that's enough of a incentive, for lack of a better word, to get a more compliant, safer system?
So a couple of things there. One is compliance is being managed by those financial institutions, irrespective of whether those transactions are being processed by BECS or by NPP. But to your point, yes, we would expect that one factor in the decision whether to move from BECS to NPP is around regulatory compliance. My point is just that there are obviously other factors at play as well. You know, financial institutions wouldn't want to run two different processes. So for, you know, some payments, they're using the existing BECS payment process, but for other payments, they're using the new NPP one. So that comprehensiveness, that ubiquity really, really matters.
Okay. I've got a few questions for AUSTRAC. Thanks.
Thanks, Mr. Laxall. Just picking up that conversation there, Mr. White. So just to help me understand, because I know Mr. Laxall has a lot more technical expertise than I do on this subject matter, but in terms of the incentive, what's your assumptions that people will move over from BECS over to the MPP? Because is it the case that the 2030 target's been dropped?
So when we think about the last leg of international payments specifically, there's probably one fact that I missed in my earlier explanation. You know, there's obviously benefit in that last leg being paid in real time, so that's a reason to move to NPP in and of itself. There's also that regulatory compliance piece. My point is just that will, at the moment, that would be balanced against ubiquity, so that sort of reach and capacity point. And then also capability. You know, if some of those transactions naturally fall into a batch, can NPP process that batch? So we would still expect those international payments to move over at some point. We expect more broadly on the transition in account to account payments. We expect some transition at some point from BECS to NPP for the majority of those account to account payments. The 2030 date we chose to drop because the feedback from both financial institutions and their customers, so large corporate, but also government departments, was that 2030 date was challenging. And so the way that we faced into that is that we have ACCC authorisation to run a roundtable between ourselves, AP Plus, who manage MPP, the RBA and Treasury, and we've created a vision for account-to-account payments in Australia, which is out for consultation currently. That vision then will lead to a roadmap, which will then make decisions around what investments are made in the account-to-account payments infrastructure when, which will then shape that transition more broadly.
But it's still the case, and I just want to get a sense from you, though, like how significant BECS is to the Australian payment system in terms of annual volumes and dollar values.
Yeah, it's still often referred to as the workhorse of the Australian payment system. So it processes around $16 trillion worth of payments every year. Probably still processes around 90% of account-to-account payments. So it's significant. And works well for payments that naturally fall into those big batch files. So if you think about large-scale welfare payments, for example, or payroll, where those payments don't necessarily need to be real time and can be processed through a batch, it's very efficient for those. So our role here is really to make sure that that BECS continues to exist and be appropriately invested in to ensure that it continues to be resilient, etc., for as long as it's needed.
But of those payments,
sorry, Chair. Sorry, can I say, but BECS can't do account verification and some of the more modern anti-scam, anti-fraud measures. That's my understanding, or am I mistaken there?
So again, the way that banks would process those kind of payments is to start with, confirmation of payee can be applied across BECS, and banks are doing that. Banks also apply risk-based friction where they need to on BECS transactions. So it can be done outside of the BECS system rather than integrated within the BECS system. An MPP would have it, or more modern real-time payment rails might have it integrated within the payment system.
So again, just another layer which you need to comply with BECS, which doesn't exist in the more modern payment.
That's right, and I guess the flip side there is that for large-scale corporates and government departments, BECS at the moment is a straight-through process for them. And so again, it's that efficiency point, which then challenges moving those types of payments to other payment rails.
Sorry, Chair. Thanks.
No, that's all right. But I mean, I know you're on the line listening because I don't mind you jumping in. But I guess my next question there would be, of those payments that I'd asked you, like what share represents, I guess, the tail end of the international transfer that arrives into Australia?
I need to take that on notice if I can, because I don't have that statistic to hand, unfortunately.
Okay. So then what Mr. Laxall just asked, and I'll just follow on too, is that is BECS technically equipped then to screen transactions against sanctions lists?
So again, that would happen outside of the BECS system. But
it would happen in the NPP system?
So my understanding on sanctions specifically is actually that would be outside of the NPP system. But again, if I can take that on notice, I can confirm that back to you, Chair.
I guess where we're going with this is just to have confidence that whatever systems we have place, but I'm just worried that there's a very large number of transactions that are occurring in this country, and yet maybe there are possibilities where not enough checks and balances are done that allows people to funnel funds into the country that potentially could finance terrorism.
Sorry, Chair, I'll let you finish.
That's, I guess, the concern where I'm going with my line of questioning here, and I'm not sure if you're able to provide anything to address that.
Yeah, so I completely understand the concern. Maybe I'll just sort of zoom out for a second and explain the thinking that's gone into the FATF recommendations, Financial Action Task Force recommendations, and then being reflected in the AML-CTF Act. This is by no means a unique issue for Australia in the sense that, as I mentioned in my opening remarks, batch payment systems form an important part of a lot of jurisdictions' payments processing, and to your question, Chair, often form the bulk in terms of volume and value of payments processed in those countries. So a good example, for example, would be NACHA, the ACH payment rail in the US. Other examples would be BACS and CHAPS in the UK. So FATF recognises the fact that batch payments are more problematic for these types of questions than single payments, because you need to understand the payments that are in the batch, and there might be thousands of those payments. So therefore, analysing them individually in real time isn't feasible. So FATF recognises that, allows for that, and so does the AML-CTF Act. So it doesn't mean that compliance is not being met. As I said in my opening remarks, the compliance obligations fall on the financial institutions or payment service providers processing those payments, but it means that they need to be done differently, extricating the relevant information from the bank.
So the arrangement covers obviously AusPayNet, members of your or member institutions and the system as a whole, or are there certain providers or institutions that aren't covered by BECS on those?
So the AML-CTF Act specifically identifies BECS as a payment system and explains what information is transferred through BECS and what isn't, and then that provides then well, I was going to say guidance, more than guidance. It provides regulation for then how any financial institutions or payment service providers then process those payments.
And when the 2030 target was dropped, I'm assuming you informed AUSTRAC?
Absolutely, yeah.
And what was their position at the time?
So from memory, they didn't have a particular position on that. I think largely because, as I mentioned earlier, I think the thinking around the AML-CTF Act and as I mentioned just now, not unique to Australia, was more sophisticated, was recognising the fact that batch payments behave differently. So probably a question for them, but effectively, if compliance can be managed irrespective of the payment channel, then that's okay.
Well, we'll have them on next. I will ask. So in practical terms, if a sanctioned entity or individuals had funds and moved them through the pathway that we're discussing, I'm just trying to understand what could potentially capture that trail of money.
No. So that would be captured. It could potentially be captured by the sending bank or financial institution or payment service provider, but ultimately the safeguard there is the receiving financial institution or payment service provider that would sanction screen, that would provide a request for more information if it's suspected money laundering, etc.
And then add cryptocurrency into the mix. So how do you think that what's been proposed could be appropriate to capture or control those risks?
So our view on cryptocurrency is that if it's being used as a payment mechanism, and I would suggest that at the moment most crypto use is actually as an asset with inverted commas around that asset, rather than as a payment mechanism. But if it's being used as a payment mechanism, then it should be regulated in exactly the same way as an Aussie dollar payment.
So do you think that needs a bit more needs to be done in terms of how we address crypto and I guess some of the risks, high risk that come with that?
Indeed, and that's why we're supportive of the crypto ATM potential regulation. I think the other point I would make there is I'm fortunate enough to sit on the advisory board for the National Anti-Scam Centre. I think that has led to some really good work in the crypto space because there was a point a couple of years ago where around 50% of scam proceeds were being processed via crypto. So actually, through the National Anti-Scam Centre, the collaboration that has led to has decreased that number significantly as financial institutions put limits in on crypto proceeds on specific digital currency exchanges, etc.
All right. Look, I'm going to leave it there unless any other members had questions. Take that as a no then. On that note, thank you, Mr. White. I appreciate you making time, given that you are currently international at the moment. So thank you for your appearance today. If there was any information that we've asked you to provide, please forward it by 12 noon on Monday, the 15th of June. We'll also send you a copy of the transcript of your evidence today. Thank you very much.
Thanks.
We'll now just take a very short break and we'll next have the Australian Transactions Reports and Analyst Centre and the Department of Home Affairs. see because they've got the focus on the lovely witnesses on the table, but I can't see the Secretariat. I don't know if broadcasting can change.
We're ready to go. Ready to go, Chair.
That's better. Okay. Okay, I now welcome representatives of the Australian Transaction Reports and Analysis Centre and the Department of Home Affairs. For the Hansard record, could I ask that you please state your full name and the capacity in which you appear before today's committee?
Jennifer McIntyre, Acting Assistant Secretary, Transnational Crime Branch from the Department of Home Affairs.
Andrew Warnes, First Assistant Secretary, Criminal Justice Division, Department of Home Affairs.
Good afternoon, everyone. I'm Daniel Mossop. I'm the National Manager for Policy, Rules and Guidance at AUSTRAC.
Good afternoon. My name is Anthony Helmond. I'm the National Manager for AUSTRAC's Law Enforcement Branch.
Excellent. All right, thank you for that. Now, although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of their respective houses. Giving false or misleading evidence is a serious matter and may be regarded as contempt for Parliament. Given the evidence today, it will be recorded by Hansard and attracts parliamentary privilege. Now, did either of you have an opening statement for today's hearing? I understand you may have circulated a copy, Department.
I had a brief opening statement that I think was circulated, yes.
Okay, you're happy for us to take it as circulated or as read and move to questions, or did you have something you'd like to point out or pull out from your opening statement?
Given the time, I'm happy to take it as read and go straight to questions.
Okay, Senator Cash.
Thank you very much, and thank you very much for appearing before the committee. Perhaps if I could address my questions in the first instance to AUSTRAC. What evidence would you say conclusively proves that the existing powers in this area are inadequate rather than being under-enforced?
Thank you, Senator. Well, I think the current powers, there's quite a difference in the way that these powers are constructed from the ones that exist currently in the AML-CTF Act and the ones in the bill. The ones that we have at the moment take a sort of case-by-case approach. So we can look at individual, what we call reporting entities, business by business, and see if they are complying. But what we can't do is have a look at a sector or a channel or a product and say, on the basis of what we are seeing here, there is an unacceptable risk that this product is not harming the community, and being able to take it from that higher level, that is something we can't currently do under the powers that we have. We have to take a much more business by business approach, which, you know, when you're dealing with really high risk things, becomes more inefficient.
So, yeah, okay, so it's not so much that there's an under-enforcement, this is actually a different regime for you.
It's a different power with a different outcome, yes.
Yeah. So can I just ask, over the last few years, has there been a trigger event that said to you, okay, the existing powers are just not enough, we need the government or the Parliament to actually move to give, as you say, that more sector channel product approach?
I think what we've seen over the last few years is a proliferation of new channels, payment methods, products, in enterprise that has come forward, and the real diversification of the market. So while there has been no one specific trigger event, I think particularly when we have looked at some of these channels, what we have seen is high levels of criminal misuse in particular sectors, and that has caused us, along with the department, to start questioning whether the policy and legislative settings are right to deal with that type of threat.
Right. And I'm assuming that this is then a global phenomenon as opposed to something that is unique to Australia in terms of that high level criminal threat moving into just different ways of doing business.
It's definitely a topic of discussion internationally, like what to do with various different things. So, you know, decentralised finance, cryptocurrency. There are a range of, and some of them are actually really good and really helpful and serve the community. Some of them are much more vulnerable to exploitation by criminal actors. So there is a real balance there that needs to be struck.
So would AUSTRAC support reporting to Parliament at a regular interval on the use of the new high-risk mechanism powers? Or if not, why not? And would there be specific information that would potentially be too sensitive to publish or reveal?
So, I mean, possibly taking that in reverse order, there may be some information that would be too sensitive to reveal in a public setting, which may form the basis as to why. It could relate to ongoing investigations. It could relate to criminal matters that are on foot, I think we are probably agnostic. It would be a decision for the department whether that went into the...
Senator, just to add there from the department's perspective, I think it's important to remember this will be a legislative instrument that will be accompanied by explanatory material. So there will be a range of information put forward to Parliament that goes along to explain what is going on and why the AUSTRAC CEO has made this legislative instrument. So Parliament will get quite a deal of visibility in that legislative instrument, and that has been ensured that it continues to remain subject to disallowance, and Parliament will have the opportunity to disallow that instrument should it wish to, and that's the standard disallowance period. No variation has been made to that as well.
Thank you for that additional information. I do appreciate that. What metrics does AUSTRAC intend to use in order to measure whether the changes in the bill are indeed effective? What minimum period would you say be long enough to begin forming those kinds of judgments? And what public reporting do you specifically commit to provide in relation to this? Just to ease any angst in terms of, will you be shutting down entire channels? You know, is the consultation period going to be enough?
So, Senator, there's obviously like a range of public consultation, and as I said, as my colleague said, there's the legislative instrument with a statement, explanatory statement that will go into Parliament. So there'll be a range of public-facing measures that are associated with the bill as it is. So AUSTRAC runs pretty public consultation processes. We've done those as we've gone through the reforms that have occurred over the last 2 years. In terms of reporting, it might depend on how the power is used, for what product, for what channel. So at the moment, obviously, we have not made any decisions, and we don't want to prejudge any decisions that may or may not be made. But there would be a range of, and depending on the size of it, it would depend on how long that consultation would went for. I think the minimum times are set out in the legislation, but that doesn't mean it's the maximum time that we would need to do. So for complex matters, we may need longer than that to consult. So I think those are the kinds of public measures that are built into the bill that we would work on to provide that visibility of what decisions are being made and why they are being made.
Is there any sort of understanding yet, and I mean it might be a self-answering question, but what metrics does AUSTRAC intend to use in order to measure whether the changes in the bill are indeed effective?
As I said, it might depend on which channel we were looking at, but usually there would need to be some sort of baseline assessment to establish the protections in the Act. So, is there a harm being caused? What is the intended outcome of any use of the limitation or banning power on that harm? And then you would have to go back and look at what the metrics are. But they might be different depending on which particular product, service or channel that you would look at. Certainly we would, I think for almost any of them, we would look at whether those product, services or channels are still operational. Can we find instances of them being operational? Can we find instances of them being advertised for operation? That would be the types of offences that are in the Act for doing that. But other than that, it might depend on what it actually is that you're banning to try and work out what the metric is.
Okay, understood. Just in your opinion, does AUSTRAC need further legislative tools and or better information sharing practices to ensure terrorism financing warnings are not actually missed?
Maybe you want to...
I think we've provided responses to questions along those lines in the past in submissions to our for the Royal Commission. I don't believe we have inadequate powers around information sharing at the moment. The AML-CTF Act does enable AUSTRAC to share its information widely where it is for the purpose of performing the duties of the AUSTRAC CEO under the AML-CTF Act.
I think there are already some strong...
So you're satisfied that the... Yeah, sorry.
Oh, sorry. I think there are already some strong requirements around terrorism funding. So, for example, our suspicious matter reporting, which is a really key feed from industry that we get in about things that are suspicious that they're seeing out there on the front line of the interaction with the financial and other systems. There is a sort of 10-day period to report those SMRs, but when they relate to terrorism financing, that's cut down to 24 hours. So there is a real sense of urgency on terrorism financing matters because of the potential impact that they can have. And we do get, obviously, far fewer SMRs related to terrorism financing. It's a different problem with a different size, but we do get that reporting in, and we do have the capability to analyse that information and share. And we do have really good sharing powers with our partner agencies, which includes all of the law enforcement, state and territory, national security agencies that you would want. They are able to directly access that information and do those searches themselves, as well as having AUSTRAC looking at them and producing financial intelligence.
Okay. My next question, I'm hoping that you are able to answer it. If not, I'll ask you to take it on notice and, if necessary, provide an answer if you needed to provide it in a confidential format. But I'll ask the question because you may say, no, we actually can answer that question. Would a better high-risk jurisdiction framework and associated practices have improved authorities' collective capacity to identify the apparent financial activity connected with the travel of the alleged perpetrators of the Bondi massacre to the Philippines ahead of the attack?
Senator, I don't think I can answer that from the table, but we'll certainly take that on notice. And
is that all right? Yeah, and I understand that you may have to, so thank you. If you could do that, thank you. As it currently stands, does the content of this bill comprehensively improve the prospects of the detection of terrorism financing risks connected to overseas travel and high-risk regions, or are there still changes that could be or should be ideally made? And if so, what are they?
Senator, from the department's perspective, this bill is focused on the things in front of you. It does some of those things around changing the definition and picking up UN sanctions. We're constantly reviewing how we are doing this in collaboration with AUSTRAC and other partners, and if anything comes to our attention, we're always happy to provide advice to government. Indeed, you'll see some of the technical matters in this bill a result of consultation we've had with industry where we continually seek to improve what we're doing. So I don't think I can answer you exhaustively. Is there nothing that we will never else need to do? We're constantly seeking to improve the regime.
Just in terms of this bill, though, and obviously this is a committee that looks into the bill, you do this all the time with us, is there anything, and I'm happy to take it on notice, just in terms of recommendations from this committee, and they often have weight, given the nature of this committee, that you would like us to put forward that could potentially improve the bill for you?
I mean, for me is maybe a question for AUSTRAC, not the department, Senator. But
yeah, and AUSTRAC as well. If AUSTRAC have any suggestions, as I said, this is quite genuine in terms of, are we giving you what you need?
There's nothing that springs to mind in terms of outstanding recommendations from the committee and other hearings or anything. I'll pass to AUSTRAC if there's anything else. Otherwise, we can take it on notice and come back if there's anything.
Thank you.
Thank you, Senator. It's a great thing to hear at a hearing. I think probably just in terms of timing, we've just done a major reform where we've been able to go in and change some of those issues that have been causing us grief over the years and tighten up in areas where we want to tighten up and loosen the reins a little bit where that's appropriate. So I think at the moment we're bedding those down. There may be things in the future in terms of how those operate, but there's probably nothing at the moment from an AUSTRAC perspective, but I will certainly take it on notice and go back and see if there are other things that people in my agency want to put on the list.
Thank you. Do you accept or not accept that there are risks in AUSTRAC not being required under the legislation to demonstrate that a ban on high-risk, non-compliant operators is more appropriate than or preferable to restricting an entire delivery channel, including low-risk compliant operators?
I'm happy to take that in the first instance and pass to Austrac. I think we're talking here about two different things. So as Mr. Mossop said already, there is an ability to deal with non-compliant high-risk operators in the individual powers. Here we're talking about a high-risk mechanism where you've decided the entire mechanism is so significant and you've met those threshold tests under 77A about the significant harm that it's causing. You've met the threshold tests in subsection 2 about what you must take into account in terms of the public interest test across the mechanism, that it becomes a different question, I think, Senator, and therefore you're able to look at the whole mechanism and that will impact across the sector or across the delivery mechanism channel. So whether or not there is low-risk compliant people operating that sector, that'll be something that factors into the risk calculus of the mechanism. Dan, I'll throw to you from an Austrac perspective.
Yeah, I think that's exactly right. Managing individual entities and, you know, like everything, there'll be good operators and bad operators generally in a sector, and that's really Austrac's bread and butter. Looking at those entities, working out, are they complying, are they material to the sector, and what is the level of maturity we expect from their compliance. That's all built into our sort of regulatory model, and we have what we call a risk-based model. So we really do look at higher risk entities more, but there is this sort of gap right at the end there about what do you do with a product or a channel that is so high risk that, you know, having it continue in operation would harm the Australian community.
Okay. So can I just ask, what objective criteria will Austrac use to determine significant harm under the legislation?
So I think significant would make it, we would give it its ordinary meaning, and that would be, you know, to distinguish it from trivial or moderate harm. So what we would be looking at is harm across a broad range of community members or to the financial system, and that harm would have to be of a level that would warrant. So it might be... It's a little bit difficult to deal in hypotheticals, but it might depend on the channel that we are looking at or the product that we're looking at. And then things like, as Mr. Warren said, like, is this a problem that is widespread across that product or channel? Are there other ways in which the same service could be applied with less risky channels?
Yeah, okay. No, thank you for that. So do businesses affected by the legislation have fewer review rights than under ASIC's product intervention power?
Thanks, Senator. I think what I'd say there is it's different. I don't think it's less. There's still review rights and you can still challenge a legislative instrument, but you don't usually have merits review against a legislative instrument. So I think that came up earlier. So you have different review rights, and so you would make a challenge to the decision under the original jurisdiction of the High Court, as I know you're well aware. And so you would have that review mechanism available to challenge that instrument. So it's just a different type of challenge and legal avenue to make the challenge. I wouldn't say it's less.
Understood. No, okay, that's fair comment. Do you concede that there is a possibility that the powers in the legislation could lead to more activity, and this has been raised by other witnesses, moving into unregulated channels? And what, if any, contingencies or safeguards will specifically be put in place to guard against that possibility? So we're not closing down something, as we all know, and then it basically phoenixes elsewhere.
Look, that can happen, Senator. It happens in anything we do in this national security space, even broader than money laundering. When you shut down one avenue for criminality, there's a potential criminality shifts. Part of the risk calculus, and I'll shift to Austrac because it's really a question operationally for them, but is it of more significant benefit to shut that payment mechanism down that's doing such harm? And then trying to work out where they shift to next and looking at whether that's something that can be more readily regulated, oversight. Do you need to then change the regulatory mechanisms for that where you think they'll shift? does Austrac CEO looking at prohibitions or restrictions in that, where you think they will go? So there's a range of things. I think Transparency International, I only caught a little bit, unfortunately, Transparency International, but I think they said it's hard. You want to be careful not getting to an over-analysis situation here. It can be difficult to know where people will shift to. Transnational organised crime, by their nature, are very adaptive, so they will constantly look for the less regulated space where they run less risk of getting caught. We will always look, and our agencies will look to close off those loopholes and shut them down. Dan, anything?
Thank you. Chair, can I just, I know I've got several more questions and I'll put them on notice if required because I know others have questions. Just in terms of the Department of Home Affairs, can I ask, why does the bill not contain some form of statutory review mechanism? Is it because, as you said, there are just other ways? Exactly right, Senator. There are other ways. We do not expect this will be a power that will be used particularly regularly. It will be a power, I think, that will be used occasionally at best, based on our discussions with Austrac. And when you look at the use of other powers in Austrac's legislation, this is going to sit at the higher end, and you will have that parliamentary review ostensibly of this every time the CEO makes that delegated legislative instrument. Okay, because so we'd actually look at it regardless. I see what you mean, okay. We'd put this, and you may have heard this to other witnesses, but given what you've just said, could there still be merit in having a formal review of any kind, including the use of, say, the CEO's extensive new powers, that's actually enshrined in the bill? Look, Senator, a review mechanism is ultimately a matter for Parliament if it wants to do it. The one thing I would say is I expect this will be used on such a sparse occasion that your review will only be looking at one example, and you get back into talking about hypotheticals about when you may wish to use it the next time. The next mechanism that might be banned might not have even been invented yet. I think that's the difficulty. I do understand what you're saying. It's just in terms of, again, just, talking to others about you've got the Law Council on one side, you've got other witnesses, on the other side. But if the legislation wasn't to fully achieve, say, what you wanted it to achieve in relation to crypto ATMs, how do we ensure that you don't then impose a ban on all such machines in Australia?
Sorry, I'm not sure.
Well, I just want, from the Austrac side, I want to be very clear that the bill is not about banning crypto ATMs. It's the banning power, which may or may not be applied to crypto ATMs. That would be a consideration that then would have to be made against the criteria in the bill.
Were you talking, sorry, was the question going to all ATM machines or just
crypto?
Sorry, I just wanted to be very clear.
Specifically crypto.
Yeah, I think that's a question for the Austrac CEO ultimately about what's necessary to protect that harm and that public interest test.
Okay, no, thank you. What specific terrorism financing gap is Schedule 2 intended to address? And is the department satisfied that the content of Schedule 2 is sufficient to fully address each of the key terrorism financing risks connected with overseas travel and high-risk jurisdictions?
Yeah, thanks very much, Senator. I think Schedule 2 it really clearly is trying to pick up some things that were introduced more recently by the Attorney General's Department. So we're satisfied when that bill was introduced and passed, we knew that we would require amendments to the definition to be able to pick those up. That's what we've done in the next available vehicle, in the AML-CTF vehicle to do that. So we've done that. It also takes the opportunity to pick up some of those UN sanctions because the way in which they've been applied has slightly changed and there's some slight technical section changes. So we have made those changes as well. We are satisfied that that closes off everything that we think it needs to. As I think a previous witness spoke about the FATF requirements and recommendation 6. It picks up those things and will make us, as we understand it, fully compliant. We'll keep that under review, and if there's ever anything else where we think there's a gap, We will always provide advice, and then, as Mr. Mossop said earlier, and I said, I think we're constantly reviewing it to make sure it's appropriate and adapted.
Can I just ask, in terms of the existing framework, how does the existing framework ensure that travel to a terrorism hotspot, followed by relevant spending activity, is appropriately identified and then escalated? And if the bill was actually passed in its current form, what does the bill then change in that respect?
I'm not sure the bill has a particular change to that aspect of it, Senator. I'm going to pass to Austrac to talk about the situation as it is and give you
as it is. Thank you.
Yeah, so geographic risk is dealt with quite specifically under the current legislation. So in every service that people provide that is covered under the Act, so it covers a range of different services. So opening a bank account is a service that's covered. People need to take into account the geographic risk of the transaction they're providing. So if you are, for example...
heading to a terrorism hotspot?
Well... you may be heading to a terrorism hotspot, but the travel is not covered. So if you spend money with a travel agent, that's not necessarily covered. What you might see are transactions that create a pattern of spending, and that would form a suspicious matter report. Now, because of the jurisdiction, that geographic risk would have been identified, and then pops a flag. Yeah. They see the geographic, see a pattern of spending that may indicate some sort of activity that they're interested in. A suspicious matter report goes to Austrac, who can then run different things through their intelligence holdings, as well as other agencies who have direct access to those suspicious matter reports. And the intel picture is sort of built up in that way. It's not a perfect system to be able to identify, and there will be many, many instances where people travel and... for completely legitimate reasons.
Because ultimately what you're trying to identify from an Austrac perspective under the Act is the financing of terrorism, right? And so it is those transactions that flag as suspicious that then start to form the intelligence picture that gets built with other agencies around. I mean, probably careful going into too much detail in a public hearing, but that's how you build out then the intelligence picture. And
that was certainly some of the work that was happening sort of back when foreign fighters were of interest.
Yes.
In a particular point in time, that sort of pattern recognition around purchases or transactions of interest could be put together by the intelligence areas, not just of Austrac, but also other partner agencies.
Another question that you may wish to take on notice, but again, I'll ask it in the event that you feel comfortable here answering it. In light of the public reporting about Sajid and Naveed Akram travelling to the southern Philippines before the Bondi massacre, has the department reviewed whether the AML-CTF framework should better capture travel-linked financial indicators? And if so, what form did the review take and what were the key findings?
Senator, as you'd appreciate, I'll take that on notice.
Yeah, no, as I said, if you needed to, thank you very much. Just very, very briefly, in terms of the term significant harm, just looping back, it isn't a defined term in the bill. Should there be better indicators as to what significant harm is, or should it be a defined term?
Senator, no, I don't believe it should be, and that's for the simple fact, as Mr Mossop said, you can see already where Austrac are going in terms of how he explained what they would consider. What you are trying to rule out is minor kind of harm, limited harm. The word significant is really trying to do the work to rule out all of the minor and trivial types of harm to enable you to focus on where is there significant harm. Defining what is significant would be a very difficult definitional issue. We use significant, I think, in a range of other circumstances to qualify thresholds. It's not, sometimes we use substantial as well. And we usually leave it to its ordinary meaning for that very reason.
Thank you. Chair, I'll conclude my questioning. I might have one or two I put on notice, but thank you all very much for your responses.
Thanks, Senator.
Thanks, Senator. Just mindful of time, but I'll just ask just a couple of questions. In terms of the reporting obligations that will be placed on what reporting obligations will be placed on designated professional services providers?
As a result of the bill or generally, Senator?
The bill.
So I don't think there are any reporting obligations that apply as a result of that bill. The question is really, certainly Schedule 1. There are...
Schedule 2, as we said, has very minor changes. We think picking up already existing obligations and clarifying those obligations. And Schedule 3 has some minor technical amendments, particularly around customer due diligence and politically exposed persons, which we think those changes... and those changes have come out of consultation with some of those sectors and actually improve and ease the burden of compliance on those sectors. So Schedule 1, not really applicable. Schedules 2 and 3, very minor, and Schedule 3 designed to improve and ease the burden for industry in complying with some of the reporting obligations.
And just for the record again, what's a politically exposed person?
Daniel, my politically exposed.
A politically exposed person is somebody who holds a role or a family member of somebody who holds a role with significant of a significant political position, be it foreign or domestic, or a member of an international organisation. So it's typically judges, senators, members of parliament, people with those types of roles who are in a position of authority and power.
And in terms of the communication that will occur, I'm assuming there's some comms plan to ensure that professional service providers understand their obligations under the new framework starting July?
Again, Senator, we're talking about the 2024 reforms more so. I'll pass to AUSTRAC, but there's been a significant amount of industry consultation. I think it's important to remember, we've been talking about regulating some of these sectors for 20 years, but the bill that regulated them was in Parliament since the middle of 2024. There's been multiple parliamentary inquiries. These things are not a surprise, and what we've done is, since the passage of the bill at the end of 2024, do an inordinate amount of industry engagement, particularly for those sectors that are new, the Tranche 2 sectors, provided guidance material. AUSTRAC have set out, I want to say hundreds, possibly thousands of pages of rules to sort of help provide some more granular detail around the obligations. So there is a lot being done with industry and with peak bodies to help train and have people understanding their obligations, Dan?
But I guess my essence of this question is that it shouldn't come as a surprise, and given you just outlined to me just before that this current bill is very minor in terms of the more broader reform package. So
yes,
okay,
that's correct.
Yeah, all right. Look, just quickly, I know Senator Cash ran through a couple of other technical aspects of the bill, but just for simplicity here, what are crypto ATMs for anyone that's watching, and what's the distinction between them and the traditional ATMs?
So a crypto ATM, sometimes called a cryptocurrency kiosk, is a machine that operates a lot like an ATM in terms of its size and appearance. The main difference is with a crypto ATM, you can deposit fiat currency or cash into that machine for the purchase of cryptocurrency or digital currencies. A private ATM or a normal ATM is more familiar to us, I think, and that's a mechanism where you can go and remove cash, or with the intelligent deposit machines, you also have that ability to deposit cash into your bank account.
And unlike traditional ATMs, can crypto ATMs, are they regulated where they can go, or there's a bit more flexibility where they can be located?
No, so the only real requirements for a crypto ATM would be electricity and a connection to an internet line to enable them to connect to the blockchain and conduct those transactions, and obviously connect to that broader blockchain. So in terms of locations, there's really no restriction on where they can go. There is nothing that regulates where they can be placed. We have about a bit over 1,700 of them in Australia. They're present in all states and territories. As you'd expect, the larger states and territories, or larger states, have a higher number of those machines. And we generally tend to see them in areas where there's higher foot traffic or commercial activity.
So is there a register of where they are located?
There is. It's a public website that you can go to that will let you have a look at where all of those machines are. It will show you who the operator of those machines is, whether they're online or not, and the address of the machines.
So for someone to have one, they need to be registered. Can anyone register to have a machine? Like, you don't have to be obviously like a bank. Like, is there a thorough checks and balance by any regulator for who can own a machine but also have it installed and so where it's installed?
Yeah, anyone can own a machine, but to have it online and active and operating, you do need to be registered as a digital currency exchange or a virtual asset service provider in Australia. To obtain that registration, you need to be enrolled with AUSTRAC, but also have your registration accepted by AUSTRAC, and there's a process that you would need to go through to have that registration accepted.
And in terms of the locations, do you know if most are located in businesses like vape shops or tobacco shops or shops of that kind?
Yeah, Senator, that's not something we've looked at in detail. In our experience, we do tend to find them in those high traffic areas. They'll be in commercial premises, shopping centres and places like that.
I guess would then deal very closely then with law enforcement agencies like the ACIC, police, in relation to individuals that might want to use those type of machines? Like, is there any oversight around the individuals that are in regular contact with these ATMs?
AUSTRAC has shared information with state and territory police, around Australia. We've done some work on who the highest volume and highest value users of the machines are, and shared that with the police. That has enabled them to conduct their own inquiries.
So what intelligence assessment has AUSTRAC made about crypto ATMs?
On the basis of the collection that we've done from the providers of these crypto ATMs, and through that we've captured the customers who've used those machines in some fairly discrete periods from the sampling that we've done, we've found that when we've looked at those users that are putting the most funds through the machines most frequently, we've looked at our own intelligence holdings, but we've also shared that information with police. Police have gone and visited many of these people to speak to them about their use of the machine as well. And in a very high proportion of cases, they've found that the people using those machines are generally scam victims, or they're money mules who are receiving funds into their account that they're then withdrawing in cash and then putting into the crypto ATMs for conversion of that cash into cryptocurrency.
Because there's a lot of reporting about the users, and from what I get a sense is that a lot of them are over the age of 50 for some reason, and I'm not sure if you've got any evidence to support that claim by what is being reported in the media. But the cohort seems to be, I get a sense, as you say, probably more about financial crime and scams, but is there any other information that you're able to provide with or share with the committee that identifies or at least has a broad sense of who in our society is using these type of ATMs?
Yeah, thanks, Senator. The people using this are represented all across Australia in both metropolitan and regional areas as well. You are quite correct that in looking at the demographics of the users of cryptocurrency ATMs, it is overwhelmingly in that category of over 50 years old. There does tend to be a far higher proportion of people in those older categories using the machines.
And as I understand it, so these machines, can be not just in those type of shops, but as you just identified, can be installed anywhere. I mean, does that not give you some concern about how it's being used as a regulator? But also, what I want to understand is how does cash get put into these machines? Surely there needs to be someone who is registered within our financial system that is putting cash in the ATM, because at some point the machines are going to run out. Do you have that level of detail? You're able to explain to me how that operates?
Yeah,
Is it the same way that the banks operate? Armaguard come and put more money in?
Yeah, that's correct. So the machines have obviously a limit on how much cash they can take. That would be monitored by the businesses that operate them. And then at a point in time where it hits that cash threshold or it's approaching that cash threshold, the machine operator would need to arrange for a cash collection operator to come and pick that money up, and then that cash would be banked.
So it's very likely then you've got people being transferred cryptocurrency, and then they go to one of these ATMs and pull out cash, and then they can use that cash within the economy. So there's no way of really tracing those individuals if they've received money from proceeds of crime or been transferred, crypto funds from, state sponsors of terrorism. I'm just trying to understand how do we track that type of level of financing, particularly in terrorism in this country. Like, I'm quite concerned that have we, in essence, got a legitimised system that is allowing individuals or groups of individuals to finance crimes in this country, and there's very little way of us trying to track how that is being pinpointed or followed back to its original source.
Senator, I might just go back a couple of steps. So for an individual to put cash into a crypto ATM, they could source that cash from a range of means. It could be their wages, it could have been a cash withdrawal over the counter at a bank or from an ATM, like a traditional ATM. So that the source of that could come from a range of different areas. In terms of the funds going into the crypto ATMs, there is no reporting obligation. AUSTRAC has put controls in place that would prevent a person from depositing more than $5,000 into one of those machines. AUSTRAC does have collection powers, though, that enable us to issue notices to the operators of those machines, which will then give us a list of customers and transactions relating to those, but they are not part of the mandatory reporting obligations. There's record-keeping obligations on the crypto machine operators, crypto ATM operators, but AUSTRAC has the ability to collect that information to allow us to track those transactions and identify who is using them.
I know we had AusPayNet earlier. I don't know if you caught the end of our conversations with them, but I just wanted to ask, when they dropped the 2030 target for BECS, what was your response to them?
So I'll take that one, Senator. So I think this relates to largely what we call the travel rule. So there is information that has to flow with transactions that occur through the banking system. So this is separate from the digital currency movement of cash, which operates on the blockchain, but there is information that needs to travel. When that travels through the BECS system, there is I guess, an exemption for that particular legacy system. That was partly because there was a retirement date for the system at the time it was granted, but also very much acknowledging the real limitations that system has. It's a product of its time, and it can only transfer, I think it has a character limit on how much information it can transfer. So if entities want to use that to facilitate their transactions, then there are other things that they need to do in the background to make sure that the information travels, and it has to be available if required. So it just physically, digitally cannot travel through the BECS system because of the limitations that it has. So I think
the limitations doesn't expose us or expose our system.
I would say not significantly, no. Like, I think ideally we would like everybody on the shiny new system, but we live in the real world, and that system does exist and will continue to exist for a few more years, and there will have to be a transition over time, I think, from the BECS system.
When?
Well, so originally we thought that would be 2030, but I think that is a matter for the industry bodies to work out how and when they can transition away from that. And I think the evidence that was
haven't provided a view?
I think AUSTRAC is relatively agnostic, provided that the risk mitigation measures that the businesses have in place are appropriate. So that's set out in the legislation, what they need to do if they are using that system. And as long as they continue to do that to mitigate and manage the risk, then AUSTRAC is agnostic about which system they use, but they may not be in terms of the efficiency and the cost of running it on different systems, which I think will increase over time if they continue to use BECS.
And I'll just hand over to Mr. Laxall now, but like my last question is that is there a way for us to capture funds that come out of sanction lists, people who are sanctioned, organisations that are sanctioned? Is there a way for us to capture those individuals or organisations using the current system with BECS?
So that would not be a system issue. I think that is an issue about the entry of the money into the financial system before the transaction even occurs. So when people are onboarded as customers, whether it's for a remittance that they want to, there are requirements under the AML Act that they have to scan people about whether they are sanctioned. There's a strict liability offence under the sanctions legislation for anybody dealing with assets of a sanctioned person. So typically the existing entities, certainly under the AML reform, are pretty paranoid about making sure that they screen for sanctions at the appropriate times before the transaction occurs, because once it's occurred, that's actually too late. And
that's a payment from here, but if it's come from overseas and received here,
it's the same, yeah. So they'll need to understand that.
All right, Mr. Laxall, I'll hand over to you, please.
Thanks, Chair. For coming today and sort of explaining this system, I come from very similar line of questioning to the Chair, just in regards to the effectiveness of, a very old, tried and tested system, but one that I have some flaws in, just that, not significantly in answer to one of the Chair's questions. Just to confirm, just based on some previous answers we received today and at another hearing, so AUSTRAC is no longer providing an exemption based on the rules of CTF.
I'm sorry, we're losing you at this end.
Jerome, I think we're losing you, mate, there. Can you just say it again?
Oh, sorry. Yeah, sorry. I just want to confirm that I was just referring to some previous evidence I was given on another committee, and I just wanted to confirm that your AUSTRAC is not providing BECS with an exemption to operate on existing rules. Is that right?
It's not an exemption. It's actually deemed compliance under the law. So there are a range of things of information that has to travel with a transaction. If that is on the BECS system, then you are deemed to have complied with those requirements to travel, for the information to travel, and that's how we work it because of those limitations of the BECS system.
Okay, but that information doesn't travel with the transaction. It has to be sought through other mechanisms. Is that right?
That's right, yes.
Okay. So, right, so I guess that's where the concerns I have with BECS, and I guess not that the system exists and not that people still using it. My concern is this removal of switchover sort of leaves this two-tiered system. So you're saying there's no exemption because the law exempts BECS, is that right?
The law deems compliance when the BECS system is used. So
even though the information's not attached to the transaction?
That's correct. And so that effectively works as an exemption for the BECS system. Probably in lay speak, that's the best way to think of it. But that information must be made available, and the sort of opposite side of the information that has to travel with the transaction is the information that must be reported to AUSTRAC if that transaction is international. And so that information still comes to AUSTRAC through a international funds transfer instruction.
Okay, and is that concurrent? How does that work? So when does AUSTRAC get that information to run those checks?
So we receive millions of those reports every year, and there's a time limit to, I think it's 10-day period to report those to AUSTRAC. So we have those reports come in, which is largely the same information as is required by the travel rule, which travels with the transaction, but then AUSTRAC gets notified as well if that's an international transaction. So as soon as a single cent crosses the international border, that information gets reported to AUSTRAC, and that's a really rich intelligence source for AUSTRAC to be able to look at those transactions and see what money is moving both into and out of Australia.
And so potentially with that 10-day lag, so do you need, so again, just clarify this, and sorry for the getting into the weeds here, I just want to try and understand this system. So there's a 10-day lag from when the transaction is made on through BEX and when AUSTRAC get the information, and then obviously you have your systems to process that information.
That's right, and that's a 10-day maximum. Okay. So a lot of, particularly our large financial institutions are set up to report those in bulk in near real time. And that's where we have the majority of those transactions. But if that happens for a much, much smaller provider, they do have a little bit of leeway under the legislation.
So, I mean, just to bring it back to high level and to the basics, right? I see this, that we do have two payment systems. Most people I've spoken to say the new one is far greater than the other one in terms of information, speed, obviously work to do for rollout. My concern, and this sort of popped up in the other committee, which you may or may not be aware of, is this removal of this transition date. I don't see what incentive there is for financial institutions to comply with these in its true form. I say comply, I don't mean comply legislatively or sort of that built-in exemption. I mean to comply with these new rules in a real-time way. I don't see, without this deadline, what's the driver for government, for financial institutions to move to this faster, better, and potentially more cost-effective system? Do you see a driver there that I'm not seeing?
There will be it'll be different for a number of different institutions. But I think the drivers are around the ability to automate compliance from an AML CTF perspective, and that's all I talk from. There may be other benefits to those types of systems, but the ability to automate that compliance, making cheaper compliance and better compliance more quickly, and the updatable nature of the new payment systems that will come into place, mean that they're more future-proofed, I guess, for other changes that may come down the regulatory pipeline.
Right, of course, and so, but what are those institutions changing now in regards to international payments?
Well, so lots of institutions are using the new payment platform. Some institutions are using both as they sort of transition. So there has been some transition, particularly amongst the major financial institutions, which is where we see
personal accounts, not so much for commercial.
Yeah, I think, but AUSTRAC is agnostic about which system they use. I think we want to see that money.
I guess this is why they're not changing, right? Like, this is sort of what I don't understand. Why is it accepted that these two systems can just sort of coexist? I guess is what I want to understand from your perspective.
Is this when we put the 2030 date in and then they ask for it to be pushed back?
Yeah. So
just to add, like, I think the position was quite clear that we want people to drive towards that level of compliance that you're talking about. That was the reason initially there was that date of 2030 put in the legislation. Now, we received advice from industry that practically that just wouldn't be possible or realistic that would be able to be complied with, so that date was pushed back. But I don't think that shifts the position that the best practice is to have that information travelling with the transaction, and that's what we'd like to get to. Can we get to it in the speed in which we originally hoped? No, but we'll continue to work with industry to figure out how quickly we can get to that.
That's right, yeah. And that date was not set by us in the legislation, so that was the date that it was scheduled outside of the AML-CTF Act to be decommissioned, and the exemption that we placed in sort of just applied to BECS as it ran. So it's open-ended at this stage, but we did not at the time think that BECS was open-ended. It had a decommission date when that change was made.
Sure, but now it doesn't. So when do you, I think it was Paynet that gave us the evidence of their new roadmap. Are you part of those discussions, or do you have to approve sort of what they come up with? What's your process in that? What's your involvement in that?
So we're involved in discussions, but we don't have to approve that. That's not our role.
So who decides when BECS is turned on?
I understand that it's the Department of Treasury who works primarily with on payment systems.
Mm-hmm. So decision of government when BECS is turned off?
I'm not sure.
Another portfolio to answer, sorry.
Right. Okay. There's obviously a disconnect between, I think, from what I've seen come into this, pretty fresh, between a system that has a lot of promise and it just doesn't seem to be a push to get there. And I don't understand that. And even from the evidence you've given me today is what I would expect, right? There is a better system out there and we should be transitioning towards it. But then people haven't, and now there's no deadline. And so I'm just, I'm left scratching my head when there is a safer system out there that, international payments should be compliant towards, but instead we've built in an exemption to the law so it doesn't have to comply, so BECS doesn't have to comply with it. Like, it's just, I find all that very bizarre.
It was built in for a legacy system, Senator, which existed, and we couldn't deny the existence of it, and we couldn't.
Understood. Understood.
In terms of mandating when people in the private sector switched over and how they managed that transition, AUSTRAC did not feel it was in the best place to decide that, and probably the department did not either. So we applied that. BECS has operated for many, many, many years, as has the travel rule, and we have not seen significant risk in the marriage of those two obligations and systems. So we have no policy position at this stage about what the date should be for the retirement of that system.
Okay, thank you.
Thanks, Mr. Laxall. Okay, well, on that note, and we're happy for you to table that opening statement from both, I think, AUSTRAC or the department from earlier.
Department, yeah, I think it's been sent. Yeah.
Okay, cool. And I think, Michaela, you're happy for us to maybe have that incorporated into Hansard?
Absolutely. Thank you, Chair.
Okay. All right. Thanks, everyone, for attending today. If we've asked you to provide any additional information, you can do so by 12 noon on Monday, the 15th of June, and we'll send you a copy of the transcript. There being no other further witnesses today, I now declare this public hearing closed.
Thank you.